We can do that.
Alright, we're gonna get started because we've got a lot to get through and information. But we are so excited to have Stephanie and Miriam and Maura, Mary Maura and Cassidy. Yeah, that's a struggle there. With us today, Stephanie is the Deputy County Attorney with the Washington County Attorney's Office and has been prosecuting for almost 9 years. Started her prosecution career in Yamhill County in Oregon, that's awesome, where she prosecuted all levels of crimes in both adult and juvenile court. And joined the Washington County Attorney's Office in March and is currently assigned to a mixed caseload, including SBU cases, so that's awesome. And Miriam graduated from DSU, now known as Utah Tech in 2021. With a bachelor's in criminal justice. She's worked for the Washington County Justice Court until she got the position with the Washington County Attorney's Office as the victim coordinator. Sorry, it's really thrown me off because I have it in my ear, so you see me pausing for a second. I have been, she's been with them for 3 years and loves what she does. And since 8th grade knew she wanted to help people, so I love that. She an advocate for them as best as she could. Being Mexican American, also knew she had a passion for helping the Hispanic community and does have plans to work on her master's degree. And big future goal is to work with the FBI as a victim advocate. They do a lot of hard work. We just work with them all week, so. They do hard work. And then Cassidy will be joining, I know for part of it as well, and she is the, here at this front table too. She's the victim witness coordinator and the adult forensic interviewer. She's been with Washington County attorneys for a little over 2 years, working with victims and survivors of domestic violence and general crimes at the district court and juvenile court. She's also attended the forensic experiential trauma interview in 2023 and stepped in the role of the primary adult forensic interviewer in January of 24. And assist law enforcement in gathering information in a trauma-informed, victim-centered way when she's not working, and she loves to spend time with her family at the gym. Sorry guys, I struggled there. But we are just so grateful that you guys are here with us today, and we will turn it all over to you.
Thank you. I realized I didn't get Cassidy on my introduction here, but don't worry, she's got her own part in this presentation. So Miriam and I are going to focus on the roles of the prosecutor and the crime victims advocate, both in juvenile and adult cases. Most of our focus is going to be on adult cases, but we're going to have time to talk about juvenile as well. There's a major theme in our presentation today, if this wants to cooperate. Do it old school, that's okay.
Oh, did it not? Did that?
Mouse move. Okay, we'll try again.
I have to click on it.
Yeah, where's this? We'll old school it. I'm just gonna click the button. Okay, it likes me now.
It just likes to lose the mouse sometimes.
Perfect. All right, so you're gonna hear us say this a lot, but our biggest theme today is we really want to talk about transparency and communication when it comes to working as a team. That is the best way that we can serve our victims. As a prosecutor, I have a very different role than the advocate does, but in order for us to best serve all of our victims, we need to be working together even within our own roles that we have. So transparency, communication, that is our really big theme for today. So in order for me to best explain what my role is in this process, I think it really helps for everyone to know what my ethical duties are. So as a lawyer, just generally, I have a thick book of rules that I have to follow in addition to all the statutes that are specifically ethical rules about how I can prosecute or how I can be an attorney within the state of Utah. There are even more rules when you choose to be a prosecutor. These are the actual specific rules when it comes to being a prosecutor and what you have to follow in addition to that other thick list of rules that we have. I wanted to flag 3 of them because when we're working with victims and working through criminal cases, all of these are always going to be in the back of our minds as a prosecutor, and they really explain a lot of what we do and why we're doing it. Number 1, first and foremost, is we cannot prosecute a crime that we don't believe that we have probable cause to prosecute. That is always going to be in the back of our minds. If we don't think we have enough evidence to get a case through, we can ethically not prosecute it. And I want to distinguish that from tough cases. This doesn't mean we can't prosecute tough cases. I did domestic violence prosecution for a really long time, and I think all of us in this room know that domestic violence is a really, really hard case to prove, especially when you have a victim that doesn't want to cooperate. They want nothing to do with this system. They're going to make it as difficult as they can for their own reasons, for their own safety. We absolutely understand that. That's not what we're talking about here. If I think I can go to jury and I've got a chance at winning, I'm going to take it all day. But if there just is not enough evidence at a very bare minimum, those are not cases we're going to be able to prosecute, and that comes up quite often. Number 2 is that we have to disclose every bit of information that we have. So as a prosecution, we give up everything. There are no secrets from the prosecution standpoint, absent, if we do a little work product or like our process in preparing for trial, that we don't have to disclose, but everything we have goes to defense. The defense actually does not have to give us anything, absent very few rules. One of our biggest disclosures that we have to provide is any exculpatory information. And essentially that is information that could either show that the defendant didn't do it or could give him some sort of excuse or defense in his case or their case, I guess. All defendants' cases. And so that's always in our back of our mind as well, is if there's something that we learn that we have to disclose, we're going to disclose it. And then just a quick note about not making any extrajudicial statements. This talks mostly about, obviously we have a lot of privacy as prosecutors. What we do is very protected. We can't just be talking to everybody about what we do with our cases, but this also is with the media as well. And that comes up a lot of times with victims, and that we have to have our communication with the victim directly. We can't give a lot of that extra information to those outside of the victim. So in the back of my mind, all 3 of these are what are in the back of my mind as I am working through a case. You all know this already, but a good refresher, all of our victim rights are in Title 77. And our biggest thing that we're going to focus on is making sure that we treat victims with dignity, respect, courtesy, and sensitivity. So both Miriam and I, whenever we're working through cases, those are also in the back of our minds. So those are really what we're working against when we are working these cases together. I also wanted to correct several misconceptions that come up a lot when it comes to prosecution of cases. Number 1, first and foremost, is the state does not represent the victim. And I think we've all heard this come up a lot. I don't, as a prosecutor, represent the victim. That doesn't mean that I don't make sure that that victim's rights are heard and their rights are treated as they need to be. I just don't represent them. And this also means that I don't have a privacy right with a victim. So anything a victim tells me, if it falls into that discovery disclosure statute, I've got to give it up. That is my rule that I've got to follow. So I always like to correct that, because a lot of times victims comes in, and I'm sure you've all heard this, is, but the prosecutor's my attorney. I'm not your attorney, I represent the state. But your voice is still important, and my job is to make sure that your voice is heard. Number 2, it is not the victim versus the defendant. Again, that same concept, it is the state versus the defendant. It's the state bringing those charges. Myself as a prosecutor, I represent the state in bringing those forward. Another one I think we hear all the time is that victims decide when to press charges and when to dismiss charges. And that is actually all the state that makes that decision. So me as the prosecutor, that is my role. I decide whether there's enough evidence to press charges on a case, or let's get to that situation where there's just not enough and we have to dismiss. And so make sure we know. And I think that's really good for a lot of victims, especially in sexual assault cases or domestic violence cases. They really struggle to want to come forward because they don't want the defendant to feel like they're the one that's doing all of this. They want to try and find to not be the blame in a prosecution going forward. So this is my favorite one to use, is that it's me. I made that decision. I'm pushing this case forward. I'm going to go forward. You can take that and say, nope, it's the state. They're making that decision. I don't have any say in it once that happens. And the last one I think everyone hears a little bit is we get a lot of victims that come in and want to give us evidence, and we can't take that as a prosecutor's office. That has to go through law enforcement. And that all comes back to all of our discovery statute. We have law enforcement not just to investigate crimes, but also to help us collect all of that evidence and make sure that it is documented easy to find, held, and that we can actually give it to them in a way that kind of makes sense. Not always, we try our best. So whenever we have victims trying to bring us evidence, whether it's text messages, I think Miriam's had photos tried to be brought forward, we always refer them back to law enforcement. I know it can be really frustrating, but just at the end of the day, we gotta go back to law enforcement to do it. So you'll hear us repeat a few of these misconceptions, but I wanted to kind of just get those out on the front end.
Yes, I was just gonna add on with that, with some of those misconceptions, as when me and Cassidy work together with their cases, we tend to let the victims know on the spot that it's the state, like, we're already having that communication. But sometimes the prosecutor has to help us out too, to reiterate that conversation back to them. Cause it does get hard, it does get messy, you're working with people that don't understand the criminal process too. So I think just communicating there always helps. Same thing with the chain of evidence, when we get victims hand us videos, pictures, I don't know, emails, anything basically that wants to help their case, we do bring it up to the prosecutor, but we still tell them to take it to law enforcement. And if they're having trouble with law enforcement, then we let them know that this is the process. If you give it to us, just know it's going to defense, and then we kind of let the victim decide if it's something they want to be given or not. So either way, there's always gonna be communication with our office, law enforcement, other advocates, things like that.
So the method to our madness and how we kind of structured this presentation is we want to go through all of the rights that victims have and talk about my role as the prosecutor and Miriam's role as the advocate, and just how we best serve victims in that role together, and making sure each right is represented for each victim. So first one, having the right to be informed of their level of protection. This is going to be one that the advocate kind of takes that lead role on. So I'll let Miriam start on this one.
So with our office, we do a couple of protected orders. One is that we can start with the criminal protective order. That criminal protective order is the length of the case. So if the case is a year, then it's for a year. If it's a month, it stays for a month. It expires when the case is like done, when the probation is done. The other one that we kind of talked about was the sentencing protective order. So that's after everything, the defendant was sentenced. And that one doesn't expire unless one of the parties dies and or the victim wants it dropped. So that's also a good one. I've done a couple for SVU cases. And then always before we do our protective orders, we also fill out safeguarded information that just protects the victim's information from the public as well.
And from the prosecutor perspective, again, you'll hear this a lot. The advocates and I very much communicate knowing what it is the victim has requested, what it is we've put in place. We do have situations where victims have asked to dismiss these PTPOs, and that's typically something that as the prosecutor, I have to ask the court to dismiss that in court. Another aspect of this specific right is whether other charges might show up related specifically to be protected. So tampering with a witness, extortion, bribery, those types of things that come up when you have a case that's prosecuting. That's the prosecutor's role to keep an eye out for those. We just had a case we just resolved last week through trial that in our preparation for the trial, it was a child sex abuse trial. We learned that not only the defendant reached out to the victim, but also had his daughter reach out to the victim to try and get the case to be dismissed and go away. So the case had already been filed, but we actually added a tampering with our witness. So just as prosecutor, communicating with your advocate, knowing if there's other things that are coming up, and we can add those other charges down the road if they fit. All right, next right we've got is going to be the right to be informed and assisted as to their role in the process. And this one really is going to be heavily a joint role. So I'll let Miriam start, and then I'll kind of tag on there how we jointly handle this, right, making sure it's being represented.
Oh, yes. So this one is, hold on, my notes are wrong.
You want me to take over?
Yes.
Okay. So the criminal justice process is really complicated and really confusing. And for victims who have not lived this, it can be really hard to explain. So it is our jobs as prosecutor and advocate to make sure that we are explaining to them what the process is and what their role is in that process. So that comes back to that misconception about this is not the state versus, or it's not the victim versus the defendant, and that the state does not represent the victim. So just letting them know at the front end those expectations and know what it is that they're going to be doing within this role. The See, I had lots of notes on this one. This one's one. This also pops up our discovery. So I talked about discovery having to provide information. Rule 16 specifically covers that. So that's how we know if victims are sharing information that, they say, well, it didn't actually happen that way, or it didn't happen at all. Those are the things that I then have to ultimately disclose to defense. So just being very transparent with the victim on the fact that anything they tell us, we have to provide over, just making sure that there are no surprises for them in what this process looks like. What else on this one? Just keeping them involved.
Yeah.
Keeping them informed and making sure that you're keeping an open communication. We know it can be hard to keep that open communication, but doing the best you can to answer questions, be available. I know a lot of the times, the advocates will take the calls with the victim. They'll ask a lot of questions that the advocate might not have the answer to, and so a lot of times they'll tap in the prosecutor to either make that call or help explain other processes to help them stay as educated and informed of the whole process as they can.
Yeah. So it goes back, obviously, we're working with people that don't understand the criminal process, so you just have to be clear with your communication. I always say, you're welcome to reach out to me, talk to me, I'm here as your advocate on these cases. But if I don't know something or legally I can't say anything, I go with the prosecutor, give them that option that the prosecutor's always there no matter what, that I'm not their just one source. It always comes down to with like, sometimes, at least for one of my examples on a case I have with the DB homicide. You think you're doing everything you can to communicate to the family, you think you're giving them everything, but sometimes it takes the victim pulling you aside saying that you're not doing enough. As an advocate, because I'm still human, it hurts hearing that I'm not doing the best because I thought I was giving them all the information on their case. But understanding their expectations and what they wanted makes you work better to be that advocate. So they even wanted updates, even if there was no updates. And to me, I didn't feel like that was necessary, but that's what the family wanted. So you just have to be clear, expect what they want, so they can understand the process, so they don't feel left out of the loop, even when there isn't anything there. Sometimes that's what just some victims and families want too.
And we know that all of our victims have gone through some level of trauma, and everybody handles trauma very differently. And so I know we can get a little bit frustrated in re-explaining information over and over again, but for the trauma brain, that's just how we're processing information. And victims are, while they might be hearing you, they're not actually internalizing a lot of what you're telling them. So
Yeah.
it might be a situation where you do have to re-explain what is going on. But again, just being compassionate and understanding that they're in a trauma brain, which again, I'm just preaching to the choir here. You guys know this better than I do about you guys know how to deal with individuals in every state that they are. I know I've learned a lot from the victim advocates, and just learning how to deal with people in their different state. Meet the victim where they are and try and just best help them as you possibly can. So right to clear explanations is a bit of a kind of, we're gonna expand on the last one. So obviously, again, extremely complicated process. And when you start a criminal case, it opens up a whole bag of worms about how this is gonna go. These are cases that take usually years, if not several years, to resolve. You are dealing with sometimes multiple individuals being involved. Law enforcement officers change, prosecutors change, judges change, just trying to explain the process to a victim. And our job as prosecutor and advocate is to give victims the most clear explanation as we can. One of the really big things I want to, again, communication, but two is transparency in the process and transparency in sentencing. When explaining what this process is gonna look like and explaining that it is gonna be slow, while they're not gonna wanna hear that because everyone wants it to go fast, hopefully it helps them understand this is unfortunately the process that we have. When it comes to resolving cases and doing plea offers, that's a really big and important part of my job as a prosecutor. I should have brought my book with me, but there's a thick book called our sentencing guidelines, and that's actually what we rely on for a lot of sentencing on cases. And it's complicated. I have to reread it every time I try and do a case anyway. And explaining what that looks like to a victim can take some time. And so being willing to take that time to explain and be very transparent. And that spills into trial as well, explaining what a trial will look like, what everyone's role is in the trial, what the victim's role, how often they need to be there, what they're, a lot of victims only want to be there just for their testimony and that's it. So understanding what they want their role to be, and kind of working around their requests as well. Explaining about, concurrent versus consecutive sentencing. If you offer a concurrent versus consecutive, what does that look like? Whether all your counts are gonna run together or stacked on top of each other. And then we throw in the parole board on top of that. I think as many of us know, in Utah, it is the indeterminate sentencing, so you get sentenced to 0 to 5. And once it's out of our hands, it goes to the parole board, and we don't have a lot of say in that. So explaining to the victim what, as best we can, that yes, they're getting sentenced to 0 to 5, but what that will look like down the road, we really don't know, but letting them know what their role will be. Trying to think about probation. What does probation look like? What types of conditions you can add on probation? What we can and can't actually ask for when it comes to probation. As I'm gonna use DV because I've done so much DV. A lot of the times with domestic violence, there's a lot of those underlying factors that apply. Like, alcohol, I feel like, is involved a lot of times with domestic violence. Not an excuse, but that's always part of it. So explaining that, we're not only trying to get some domestic violence treatment, we want to get some alcohol treatment. Those are all things we can ask for because there's a nexus to it. But if we have a case with somebody who the victim is saying, well, I know that they have mental health issues and I think that that's what's causing this, and I don't have a nexus to actually ask for that, it's not something I'm going to be able to ask for in sentencing. So just being very transparent to a victim and not giving any unreasonable expectations. Because at the end of the day, and I think Maren will hit on this, we don't want to guarantee something that we cannot provide. We can never guarantee an outcome of a trial. We can never guarantee how the process is going to go. We can never guarantee when the process is going to end. And just being transparent that we're not going to make you any false promises. Because I don't want them to have something happen and say either I didn't prep them for it, or you told me that was something that wasn't going to happen. One of my best examples is, as many of you've seen in a trial, when you get to the state resting their case, the defense like to make a motion that the state hasn't presented enough evidence and the case should just be dismissed. That happens in almost every trial that you go to. And when a victim hears that, that can be really shocking. Like, why is this defense attorney asking for that? So one of my trial preparations is I like to prepare the victim for that and what the outcome could be. Most of the time, the judge is going to say, no, there's enough, we're going to go forward, all charges are going forward, but letting them know that we might lose a charge or two, we might end up losing all the charges, but just having them have as much expectation about what could happen, just to make them be most prepared.
No, that's true. So at trial, we're obviously there for the victim. We support the victim at trial. We help them out with questions, mainly because we're the front people with them in the gallery and the prosecutors behind. Sometimes if the prosecutor has time, we'll chat with the prosecutors just so they can have a better and clearer expectation of what's going on. But I do my best to help them during the trial process, during the preparation, during the meetings, anyway, during that line, we're there and being transparent as we can. Because at the end of the day, we don't want to give out estimates or promises that we can't guarantee the families.
We got a quick announcement. Pause.
Sorry, guys, just for those that are in the room, I'm just getting from the hotel that there are 12 vehicles parked in the front area where they have cones and a barricade set up for construction. So if you believe you're parked somewhere in the front area, if you guys could go check and move your vehicle, they would really appreciate that, because there's 12 cars in that area. Thanks. It's like right in the front, and he added cones, I guess, at lunchtime. So,
But we're, weird.
We want to take a quick.
oh, I think you can move them just to the side of the hotel. Wherever
this
there's not
side?
cones.
Yeah.
Sorry, guys.
No, you're good. Do you want us to call it?
We could take a 5 minutes.
Want to take a 5 minute?
Just so people don't miss.
Yeah.
Yes.
We'll take a 5 minute.
Sorry, guys.
No, it's okay. That's how these things go.
So are you on the right here?
Yeah.
Yeah, clicked on that side.
That's what, I parked on that side too.
I didn't see those.
I didn't either, so I think we should be fine.
They're just like,
You're like, hello?
can take a breath for a second and turn in.
No. Are you turning it off? I don't know.
I'll mute it for a second here. Just mute. Up to 5 minutes. Okay, sorry guys about that minute break here. But we will let them still take it away. You guys can come in. Hopefully you're.
Oh, yeah. Okay, so back up there. Oh, yeah. Back to clear explanations. Again, this is just going back to communication. One of the other things we like to warn victims about is the defendant's statements or lack thereof. As we all know, defendants have the Fifth Amendment right to stay silent throughout the entire process. And we know that a lot of times victims would love to know why. Why did the defendant do this? I want some sort of explanation. And at the end of the day, the law says they don't have to give any statement whatsoever. So just prepping them for that, whether it's at arraignment, whether it's preliminary hearing, whether it's at trial, whether it's at sentencing, the likelihood of a defendant saying anything is gonna be pretty rare. And if they do say something, it is more than likely not going to be something that the victim wants to hear. So you kind of have to take their statement with a grain of salt, knowing that pulling from Get Cash, she tells this to victims, take it with a grain of salt. It's really not going to it's not gonna satisfy a victim, unfortunately, and sometimes it does. I had a case, we actually had a sex abuse case resolved this week where the defendant actually did write a very heartfelt letter and did apologize for his actions and did take accountability, and that's just more the rare case. So just preparing them for those statements, especially when we get to trial and a defense attorney is gonna get up and give their opening statement about what the case will be. Just be prepared that it's not gonna be anything that you wanna hear. So again, just being very, very honest and transparent about what this is gonna look like to best prepare the victim for anything that could or will happen during the process of a criminal case. Anything else you want to add, Marie?
Yeah, I guess just going back to that trial is that we just help them understand trial. We help them kind of prepare for defense, but we can only do so much with the defense side because you never know what they're gonna ask their victims. I had a thought and it disappeared, but I'll just leave it at that. It just goes back as communication and then just being as transparent as you can with the victim or the victim's families as well.
Yeah, in that case, we also resolved that
Yeah.
case, and that victim, we involved a lot in the plea offer negotiations. I think she came to our office every day for a week trying to get us to a resolution. Part of it did include sex offender registration, so again, just being transparent about, yes, there is a lifetime registration on some of these cases, some of them it's 10-year. But even when we say lifetime registration, you can ask for relief after 20. So it's just all the little pieces to just really help them understand as best as possible. And as long as you got a good team between your prosecutor and your victim advocate, hopefully we can do the best we can for them and answer every question as best as we can to get them through this process as painlessly as possible. We know that that's really hard to do, but our goal is to really just try and make this as easy for them as it can be given the situation we're in. Next right we have is the right to a secure waiting area. This is gonna be more of an advocate run role, so I'm gonna let Miriam take over on this one.
So as I mentioned, with the secure waiting area, our office is pretty secure, so it's not like we actually never see a defendant. If we do, it's probably the defense attorney, but they go straight to the prosecutor's office. So with victims and families, we have a small waiting area. Cass will hit on her office where she does the forensic interviews and how that looks like. And then in meetings, we usually have a conference room, shut the door, the blinds are always closed off too. And then we're there with the victim and we always ensure them that they can have extra support if they want to. So they can be there not alone, but they can have a mom, dad, sister, brother, whoever they want in that meeting. As far as the courthouse, we are always there as long as the victim wants. If the victim doesn't want our support, then we won't push it on them. With kids, especially with the SVU cases, with kids under, I think it's 14 is what the judges let me, I can be on the stand with them. I can't obviously say anything, I can't like help them out with their testimony, but I'm there as a comfort and I've noticed that does help the kid a little bit. And or the teenager that's on the stand. So That's another way that our courthouse lets us be with the kids on those cases. It's different in juvenile court, unfortunately, but juvenile court is private. So it protects that privacy for the juveniles, because we are dealing with the minor that's an offender and victim that's a minor as well. With courthouse, we also make sure we have good, at least me and Cass have good rapport with our bailiffs. So if something does go wrong, or if a family's making comments or smirks, then we obviously communicate with the prosecutor as much as they can, check their phones if anything. Or we text the bailiffs and be like, hey, this person needs to be kicked out, unfortunately. That helps them too. Or we block people from like seeing the victim, things like that, to just make it as easy as possible as we can for those victims and families.
And as for the prosecutor, we still do play a role. We let, again, advocate take really that lead role in this, but it's good for the prosecutor to be aware of what it is that the victim or their family is requesting. Also, just being aware of your facilities and how you can help facilitate that secure waiting area. Trying to, make sure there's not any, bottleneck out the door when a defendant's family is leaving and then a victim's family is leaving. So just trying to help facilitate those logistics. And we actually had a situation come up this week on a case.
Yeah.
It's an aggravated assault shooting case.
Yeah.
Where the victims and family were there, the defendant's family was there, but the defendant actually turned around and smirked at our victim. I missed it, but luckily, we had a couple other people. I think Miriam actually caught it.
I caught it.
So did one of another prosecutors in our courtroom. It's just something that we can be aware of, and next time we go in court, keep an eye out for, and if we need to get the court involved to admonish against that, we can get them involved in that. Our office is set up, like Miriam said, our office is in a different building from the courthouse. So a lot of times when we meet, whether it's to go over for sentencing or to go over for trial, we have a nice way that we can meet them and walk together to kind of help alleviate any of that contact or accidental contact that might come up. So know your courthouse, know your facilities, know your staff, know your court staff. They are gonna be the ones to help you the most. So just know everyone and get a good reputation with everyone. The right to seek restitution. This is a very complicated part of these rights, because the law for restitution is very long and lengthy, and it's very specific in what we can and can't ask for restitution. So this really is gonna be a prosecutor driven right. Advocates play a very important role in making sure that the victim is aware that they can ask for restitution, that there are some ways, referring over to UOBC is a really big help for the victim advocate to talk to victims, and then helping get supporting documentation. So for the prosecutor, just making sure that you're vetting any requests that come in, make sure that it fits the law, because we don't want to be going to a restitution hearing. I'd hate to drag a victim in with all this information and then not actually have the law behind me to actually get that restitution. We want to avoid any contested hearings where we need to. So just checking. So the damages we can get are any demonstrable economic damages, losses, and expenses regarding whether the economic injury, losses, and expenses have yet been insured. We really want to point out this does not include punitive damage or pain or suffering. So if that's something a victim is looking for, I know our advocates will tell them you might have to go look in the civil world. There's so much we can do in the criminal world, but that does not shut off your options for the civil world. And kind of let Miriam take on that.
Yes. So as always, my first choice is always gonna be UOBC. Why? UOBC is a fast resource. They're gonna get their reimbursement most likely right away, as long as they are approved. That will always be my first resources for any SVU cases and or Spanish speaking cases. Second, if for some reason they don't get approved or they can't, I try to help them with the UOBC application too, to make it as much as easier for them, and that helps them too. The second is that I get the numbers, the receipts, invoices, medical bills, whatever it is that they are seeking restitution for. I do the numbers for them, make sure it's their number that they want, give it to the prosecutor, and then she or he will tell it in court. If there's ever a weird issue with defense or anything like that, then we get our resources, and then we usually have a restitution hearing. Lately with restitution, I have noticed, I don't know if any other counties have it, but at least in 2 of my cases, and I think they're both juvenile SVU cases, UOBC paid out for the sexual exam or the rape kit. And unfortunately, I have been seeing defense push back on that and not be wanting to pay that. So usually I like get my contact from UOBC and say, hey, this is what's going on. What can you provide? Obviously, they have limitations of what to provide for us. But we'll do whatever they can so UOBC can get that reimbursement. So maybe look out for that because at least it's happened in 2 of my cases. And then, of course, the civil resources. I try my best to understand the civil resources and then provide them to the victims. So if they want to sue for pain and suffering, they are able to get that help as well.
And this all comes back to giving real clear explanations as well. You know, let's think about a case where we have a cell phone that was damaged. We can only replace the replacement value.
Yeah.
So if a victim decides to go upgrade their phone, we can't provide anything above what would have been like an equal pay for that cell phone. So those are the things that are going through the prosecutor's head as we're looking at these statutes to make sure that it is feeding the statute and they are getting compensation for what the law will actually allow.
Mhm.
But that still doesn't shut off the civil world. That's always an option for a victim if they want to go seek that route
Yeah.
for something further.
We just make it clear, at least me and Cass make it clear that whatever you ask for UOBC or for the state, you can't do it civilly, because as we know, that's double dipping. So we just make it very clear what they can and can't ask for on our end, so they can move forward with the civil suit, if anything.
Right to have property returned. This is something that we in our office see quite often. And really, this is quite a joint process between the advocate and myself or any prosecutor within our office. Again, the advocate kind of communicating with the prosecutor what property, if any, is being requested, and then from the prosecutor going and working on how we can get that returned. So I know we've had several cases with cell phones, different items, where I've either reached out to the defense attorney and asked if that's something they would agree, or after looking at the case, if it's not a very important piece of evidence that we wouldn't need for trial, we could do an early evidence release for a specific type of evidence. Cassidy and I actually had a case recently with a defendant. When he got arrested, he had parked his car in a way in the parking lot in her driveway that no other car could get in or out. And it was forcing her to park on the street, and she lives in an HOA neighborhood. So it is now becoming an issue on whether she's gonna get fined or both the cars are just gonna get towed. Unfortunately, this was one we weren't able to work out, but I did attempt to reach out with the defense attorney. Sometimes we can get there, sometimes we can't. I think this one did end up working itself out down the road. I think he got out of custody, so it didn't matter.
They could move it.
But just being really communicative, seeing if there's anything you can do, and just doing our best to try and help the victims if we can. Even if it's just, hey, we really tried, we've made that effort. Unfortunately, we weren't able to make it happen for you, but let's keep trying to see what we can do. Also important to distinguish, there's kind of 2 different places that evidence gets taken. If evidence gets taken into evidence with a law enforcement officer, that is something that our office can help get a property release for. If they were booked with it, we can't touch anything they were booked with. So that was with this case, is the keys were in his jail booking. We had no way we could access any of that without either his permission or the defense attorney's permission. So just being aware of where everything is and just being willing to take the time to follow that hole and see if there's anything you can do. And then if not, just sort of be aware in the back of your mind if you can maybe try and get a case resolved quicker to resolve an issue, or find a way to prove your case without that specific piece of evidence. But if you can't, just really explain to the victim why it's not something that you could get back, and that you'll do your best to get it back at the end of the case once it's over.
Yes, just to highlight, I had a case, I don't remember how the child had the child pornography. I don't think he was a defendant, but anyways, phones like that, you have to be transparent. Obviously, those can't be given back to anybody. Law enforcement destroys it. I think sometimes we can get restitution for phone destroyed, but I don't know. Sometimes, I think it depends, but it's obviously you're losing a phone, so people get upset, but you just have to explain, like, legally, we can't give a phone that has child pornography or any type of pornography. And then you can just go back to your resources and see how either the phone company can help them out or how you can help them out as well.
So next right, I want to talk about is right to reasonable employer intercession services. I'm gonna let Miriam take this one because this is gonna be, again, collaborative effort, but more of a victim advocate direct dealing with the victims on this issue.
So this one kind of hits more with subpoenas. Nobody likes to miss work, nobody likes to be subpoenaed for court, nobody wants to testify. But we're willing to help them out. So I had a case where the mom's workplace was just being really rude and not letting her be with her son as support, and she was a single mom, so the kiddo couldn't be alone with just us. And then Jerry Jager, actually, he said that like, hey, if you're having issues, like, I'll take it firsthand and then I'll call your employer, because legally with the subpoena, they have to let you come and testify or take those days off, whatever it is. Again, it goes back to UOBC. We can use the lost wages with them. And we can also see, well, in the subpoena, you get a small fee given to you. It's not a lot, but you can always have the prosecutor sign it. They can turn it into the court and they get a check for, I think here it's like 18. So 18 something. So yeah, so it's not a lot. And then they get, like I said, they have you oversee for the lost wages as well. But if you have family members or the victim personally who can't get out of work with the subpoena because they just have a grouchy boss, talk to your prosecutor and they can usually step in and talk to that boss or whoever needs to be spoken to.
Yeah, so again, communication is really gonna be key, for the prosecutor's role, obviously being really good about ensuring the victim advocate knows when next hearings are and which hearings are gonna be required for the victim to be at. And then also just getting subpoenas out as soon as possible. The sooner victims can plan, hopefully the less likely they'll have these issues. But if they do, we'll take them as they are. Also, when it comes to trial, we understand that that is a huge commitment, not just for victims, but for family as well. So trying to work around schedules if possible. I know that's something that I tend to have a conversation with. I know our preference is that victims and family be there the whole time, but we recognize that life doesn't stop for our trial system or our criminal system. But if we can work some sort of schedule out that will help them have that support person there, let's do our best to do it. I mean, as prosecutor, we have a bit of control since we present the case first. We are the ones putting on witnesses first. We have quite a bit of control on scheduling and can move witnesses around and make some changes to help accommodate some of these issues that come out. So again, just communicating with each other to try and best solve these issues on the front end. All right, right to speedy disposition. This is obviously kind of a frustrating topic to cover because we know that these cases, like we said, take anywhere from a couple months to a couple years. I think I've got a case right now. It does not have an actual victim, but it is 5 years old at this point. These are just, they're not fast. And the defendants have a lot of constitutional rights, and their rights are almost always going to take priority over a victim's rights. But that doesn't mean the victim's right to a speedy disposition goes away, because it's still really important for us as prosecutors to remind the court, especially when we have individuals who are asking for pretty ridiculous continuances all the time, to make sure that we are voicing the victim's right to be heard. So taking the lead, making sure things that are going through, not letting things linger out. We tend to see a lot of these cases just get bumped for continuance and continuance. And when they just aren't moving and they become stagnant, that's the time when we start pushing for either setting for a preliminary hearing or setting for trial. While that's not ideal, we'd love to resolve cases. Sometimes you got to get those set to help make sure that victims are getting this right as best as they can, even knowing that defendants' rights are always kind of be a little bit ahead of them on this one.
Yeah. So with this, I explain the process to the victim. I'm like, okay, this is what's gonna happen. We're gonna do trial. And let's say it gets continued. We have a couple of cases where unfortunately the trial cases keep getting continued and continued. With us, the first priority is gonna be the ones that are older and in inmates. So if they're in custody, those are always gonna take first priority. We try to explain that to the victim, not wording it as first priority, but just explaining to them that unfortunately, this case has just a higher leverage than other cases, especially if they're out of custody. Those are just gonna take a little bit longer, and you just gotta be transparent, help them out, understand, and just be cautious of how you do it, because people are gonna get upset with that, especially when the trial doesn't happen when they want it to.
Yeah, in custody, child cases are always gonna get that #1 priority spot, and then from there, they'll trickle whether age or out of custody.
Yeah.
So just again, being transparent with victims
With
on
victims.
these types of issues. So right to timely notice, again, this is a huge joint role between the two of us. Mary, do you wanna take lead on this one?
Yes, so when me and Cass do our initial phone call, or when we get the first case and we're trying to pinpoint the child, the victim, whoever it is, We always ask them, okay, this is who we are. Do you want updates on your case? They say yes or no. If they say no, then we're like, hey, we're still gonna give you our contact information. If you still have questions or you wanna know what's going on, then you know how to reach us. If they say yes, we tell them, do you want phone calls, emails, text messages?
I added one little thing in with my thing, if people don't want updates, I've started saying, are you willing to testify if needed? Because then we don't have to try to track them down. We have, I mean, it's not a solid yes or no.
Yeah.
But then they have that in the back of their head that this isn't just gonna go away.
That's true. She did hit that, and that is true, because sometimes when they don't want to be updated, they don't want to testify, and then we just gotta work those matters out with the prosecutor and see how we're gonna move forward with the case. And then from there, once we know dates, once we know times, once we know anything else going on in our office, we make sure we either call the victim, text the victim, email the victim on how they want to be informed, and make sure to give them updates as soon as we know anything. If we don't have updates or if we don't have dates, then we just say, hey, not much is going on right now, but once we know something, we'll let you know as soon as possible.
Right, and then just kind of as a refresher, I mean, you all are aware that there are very specific rights when it comes to sexual offense cases, so just wanted to flag those again to just remind everyone about, you know, the request to be able to get HIV testing, not being charged for forensic interviews, or sorry, for the forensic assault kit evidence, about DNA profiles. One of the big ones I wanted to flag is that in sexual offense cases, you can actually designate a representative to receive information. I think obviously you guys are all aware of that. As a prosecutor, that is great information for me to know, because like I said at the very beginning, we're limited in who we can share our information with and what we can share. But if a victim in a sexual assault case is designating representative, that then opens my communication abilities with that individual to help the victim get through the process, but then have someone who can be their right-hand man to help them through and understand everything that's going on. So again, these are all gonna be dual rights communication. Just make sure that if a victim has elected to want one of these rights, that those are being shared so that they are not being missed down the road. And then if we have a child as a victim, there's some additional rights there that we want to protect. So obviously protect from any physical or emotional abuse during your during the criminal justice process. That if there's adults acting inappropriately, inappropriate behavior of adults committed against them, and they don't have to be questioned in any manner. Interviews being kept at a minimum, hence why we have our CJCs, which are amazing. Being informed of community resources, and then keeping confidential those CJC interviews as well. So a couple extra rights that pop up. I think you're doing more on that too. So I'm not going to more, just a reminder until a little spoiler before Christy gets to hers. So we have a very unique aspect in our victim advocate program. So we're going to turn it over to Cass to talk about our adult forensic interview program.
Hi.
You want us to just stand up here?
If you want, I don't really care. Yeah, do you want to hit my thingy?
Yeah, I'll be in charge.
Okay, that's me. So Vicky read my little bio, but that's just a little bit more about me and whatever, we can skip past that. Okay, so this is our forensic interview room and it is housed at the Washington County Attorney's Office. It's up on the 3rd floor. You actually have to have like a key or our little badge to get into the room, so it's very secure. This is only a portion of the room. It continues on and it's fairly large actually, but this is the only portion that I use with the people I'm talking with. So there's 2 different cameras. There's gonna be one like over on this wall and then one up on the ceiling. So we're capturing 2 different angles. We have 2 different microphones. One is actually hidden in that plant there, and then one is next to that tissue box. Yeah.
Next, maybe, yep.
Okay, so why do we do this? And I'll kind of preface by saying, this is unique. I was talking with Christy and just kind of, cause I don't know of any other organizations or people or anywhere that has what we have with an adult forensic interviewer. I think there may be some in Texas that I've heard, but this is the only one that I know of in Utah. So it's similar to like a CJC type of deal, but it's strictly for adults. And it's not through detectives. It's a very unique situation. And I'll touch on that a little bit more later. But it's trauma-informed, victim-centered. There's continuity throughout Washington County. It's beneficial when presenting evidence in court, that touches back on that continuity stuff. So Washington County Attorney's Office. So our prosecutors have noticed the quality of the interview matters to the fact finder. It's defensible in court. And then law enforcement is accustomed to interrogation techniques, whereas adult forensic interviewing is completely victim-centered, and then it's evidence-based.
I'm gonna jump in just briefly. As a prosecutor, having these are really beneficial. I know that in a lot of cases, especially whether it's sexual offense or domestic violence, the defense attorney and the defendant really wanna see what the victim's gonna say. And if you can put a video of their disclosure up in front of them, they have all of it right in front of them. They essentially know what's gonna be presented and what the evidence is in this case. The likelihood of getting a resolution does go up a bit. Obviously, that's not guaranteed, but it does help facilitate resolution when you have this thing that you can put right in front of their face for them to see.
Yes.
Sorry, jumped in there.
You're good. Okay, I'm gonna step over here so I don't have to rubberneck. So this is kind of the process of a forensic interview. So a sexual offense or a crime with special circumstances has occurred. So like just last week, I sat down with a girl who has been just physically assaulted for the past 2 years by her husband. And it just now is being reported, because she was scared. But it was egregious enough that the detective felt that it was more important for me to sit down and talk with her than him talking with her. The case gets passed to investigations, detective reaches out to me to get an interview scheduled. The detective coordinates with the victim regarding the interview. I don't have any communication with the victim until they come into the office that day for their interview. And then after, I don't have any communication with them after, unless I run into them somewhere. Where Miriam and I are the only advocates in our office, we just kind of have a rule in place where if I interview them, I cannot be their advocate because it's a conflict of interest. So this assault case where that case typically would come to me, that I interviewed last week, it's gotta go to Miriam because I sat down and I was there interviewing her. The interview takes place at the attorney's office. It's observed by law enforcement from a different room. We record everything. Technology is crazy, so we do our audio and video recorder, our big system, and then I just have one of the little handheld audio guys that I bring in with me. I always tell a victim, hey, this is going to be recorded. I'm gonna go start this. This is a handheld audio recorder, so they know what is going on, what different things are. And yeah. Oh, I don't know how to do that. Okay.
I'll let you.
I don't know what I'm doing. So in a forensic interview, the victim or the participant should be doing like 95% of the talking. I shouldn't say only. I am asking open-ended questions and I'm avoiding those direct questions if necessary. So basically, I don't know if it's big enough. So this is the sheet I bring in with me while I interview people. So I have been doing it, I guess a little over a year now. So I don't read verbatim because I want to be able to look this person in the eyes and be able to talk to them. I don't want to sit and read off my paper, but if I get mixed up, whatever, I have something to refer back to. So the first part is just very procedural, making sure we have their name spelled correctly, getting their date of birth, letting them know where we're at, just kind of record related things. I let them know that they're here voluntarily and then what my role is. And I'm literally just a neutral person asking questions. It is really hard for me to turn my victim advocate hat versus my forensic interview hat because I am an empath. I want to be here with you and be like, oh my gosh, yes, or whatever it may be, but I can't do that when I'm interviewing. It's actually been a lot easier than I thought because I can see that I'm still being a good victim advocate by showing up and creating this safe place for them, even if I'm not looking at them and validating every single thing they're saying. Yeah, I open it up by saying, what, if anything, are you able to share with me about why you're here today? It's an open-ended question. I've had some people go for 5 minutes and tell me what's going on. I've had some people go for an hour and a half and tell me what's going on. I don't say a single word.
I sit there and I nod my head or I say, whatever, to let them know they can continue. But I just let them go. When they do stop, there's a lot of breaks that they'll take because they sit and they think, or they're crying, or they're just different things. So I sit in silence with them for a minute or so. If they continue, I'll let them continue. If I feel like, okay, this is appropriate for me to step in and say something now, I will. I'll typically, after that initial narrative, I'll say, thank you so much for sharing that with me. Tell me everything about whatever, to start getting more information. These other little things are just cues of what I can say if I'm stumped as to what to say. One of the huge things is talking about their senses. So tell me everything you're able to see. Because sometimes, I don't know how many of you have seen Trent Dressen present, but there's one time he explained, I think it was him at least, that a victim during an assault could stare at like a spot on the ceiling. And that was the one thing that they could see. So anyways, just getting all those little things. Let's see here. Oh, what happens next? Okay. Well, one thing on, yeah, anyways, okay. I'm trying to think of where I was going with that. Halfway through the interview or halfway near the end, I'll step out. We don't know where halfway is. But I'll step out, I'll talk to the detective and say, hey, I'm not a detective. I don't have this background. So it's like, okay, what do you need? What details, whatever, all these things. They'll say to me, okay, I need this, this, and this. And I'll go back in and I'll answer, or I'll ask them these questions. If I have to ask a direct question, I will, but I avoid it. Sometimes they'll dance around different things. And sometimes I have to be direct and say, where was his penis? Or different things like that. Because they just don't, it's uncomfortable. Yeah, okay. So what happens next, after I'm done with my interview portion, I'll again thank them for coming in. I'll ask them if they have any questions for me. 99% of the time, they're gonna say, what happens next? And I say, I'm actually gonna refer you to the detective because I still wanna remain that neutral person. So the detective will come up. I recently have incorporated asking the victim if they want me to stay in the room with them or if they want me to step out. Because I've just sat there with them for who knows how long, and I've built this relationship with them. And sometimes they're not comfortable with just the detective in there. And so I've started opening that up. And sometimes they're like, yeah, please stay. Sometimes they're like, oh, I don't really care. So I just do whatever feels right. So next step, the detective will come up, tell them what's going on, let them know the next steps in the process. They'll gather any like phone numbers, addresses, different things like that, if applicable, that came up during the interview. Detectives will do their detective stuff. Talk with witnesses, follow up on leads, talk to the suspect, do all that type of stuff. So after that is complete, they will send in a staffing request to me and my boss. I schedule all the staffings. It just goes to him in case I'm not there. And that is the prosecutors who staff these cases. It's our special victim team. So Ryan Sham, who you guys saw earlier, Stephanie, and then a couple other prosecutors. They'll come in, they'll sit down with the detective, and the detective will present their case. I have been trying to go to those staffings as well in case something is misunderstood by the detective, because we're all human, or if they forgot something that I felt was important. And also another aspect of that is I like to go so I can learn what it is, like what kind of questions the prosecutors are asking, so that I can better formulate the questions in my interviews to help support not only the detectives, but the prosecution as well. Typically, the prosecutors will decide right there if they're gonna file charges. Sometimes they'll say, hey, we need more of X, Y, and Z. Detectives will go out, do more of that, and then they'll come back. We'll decide if an arrest needs to be made and that type of stuff. Which one is it? Doesn't matter. Christy, are you talking about child forensic interviews? Okay.
Yeah, but go ahead.
Okay, I just won't go too in depth in that because I don't know child forensic interviews as well. But this is the main difference between the adult and the child interviews. So location, obviously, you've got the CJC and then the county attorney's office. Brooke Triplett is our forensic interviewer for children. She is phenomenal. I've learned so much from her. The intro questions are going to be different. With kids, they're gonna be building rapport. They're gonna be
asking different questions and formulating things a little different, things like that, where the adults, they know why they're talking to me. And so I can kind of get right into it. Obviously, if they're not ready, I kind of fill that out, but 9 times out of 10, we can get just right into it. And yeah, the intro is different and all that type of stuff. Maybe. Oh, I'm on the wrong screen.
Oh, the mouse is great.
Go this way?
Yeah.
There it goes, okay.
Yeah, sorry, it's
Moving?
special today. There you go.
Why is it not moving? I don't know, I broke it. Oh, there you go. Okay, does anybody have questions?
So these cases have no correlation to a child abuse case that you would typically see there. How did it come to be that you would post this at the Children's Justice Center?
So I don't do anything at the Children's Justice
You
Center.
don't do the interviews.
So I strictly interview adults, so anybody over the age of 18, I am interviewing at the county attorney's office in that room that I showed. The only people that I would not interview that are over the age of 18 is if they have like mental, like if they are more at like the developmental age of a child, I'll send them to Brooke and have Brooke interview them. Or I've had a couple of instances recently where I'm talking to these young 18, 19-year-olds and they're not mature for their age. And so I've talked with Brooke and I'm like, okay, what should we do with this? Because we want to make sure that we're getting the most beneficial use out of what we do. And so if I'm gonna just start trying to implement, if the victim or the person I'm talking to is 18, I'm gonna say, hey, to the detective, hey, help me understand kind of where they're at. Do you think it would be more appropriate for me to interview them or to have Brooke interview them? Cause I've only had a handful of them like that, but I think that we want to make sure that we're doing things the best way for these adults and the kids. But yeah, any other questions?
With defense attorneys, have they ever pushed back on having anyone other than a detective do that interview?
Steph, have you seen anything?
So I have not had one of these yet, but I haven't heard that there've been any issues.
Yeah.
That I'm aware.
That's incredible.
Yeah, I haven't heard of any issues. So this program, do you remember when this first started?
Maybe 4 years ago.
4 or 5 years ago it
Yeah.
started. I've talked to Ryan Shaw a lot about it, and he has said just how it's been such an asset. And the prosecutors really love it because, I mean, you guys see the CJC ones, how you have the consistency of the same person, you trust this person. And detectives, we know and we love them, but sometimes they fall back into that interrogation.
Oh, yeah.
And so
Well,
this
they
is
also
just,
paid out
yeah,
quicker than that.
Yeah.
So I see this is
Mhm.
highly beneficial. I'm just kind of trying to figure out how it can spread.
yeah, and I'm really trying, I was just talking to Christy about it. I would love to talk to people about this to get this started in other places. We originated under a grant, but we have since absorbed this as an office because we have seen such great success with it. Eric Clark, our former county attorney, he helped absorb this into our office because he saw the benefit and the positive outcome of this. Yes.
I'm a little confused. Who all have access to these interviews to actually view it?
Yeah.
Can the victim say they don't want anybody hearing it, but, I mean, does the defense and then have access to these?
Yes,
Does anyone who wanna see it?
not
Only certain
essentially.
people have access, right?
Yeah, so,
Can she deny access? I mean, could she say, I don't want anybody to see it, but my detective or?
So I'll handle that one because this comes back to discovery. So if this is a case that we end up prosecuting, then we would have to give it over. But if it becomes a situation which this is where obviously talking to victims and yes, the victims aren't the ones that decide whether to proceed forward, but as a prosecutor, it's an important conversation to have. Is this something you want to go forward on? If they're just not ready to do that, maybe it's not the right time. Nobody else would see that. That would just stay, I think, within our system, within the law enforcement system, if we don't end up filing charges.
I've had great victims say, I'm so tired of telling everybody what happened.
Yeah.
They come in, what happened to you, what happened to you, what happened to you?
Yeah.
I would think this would be a good way to get their story over once.
Yep.
and not have to repeat it to everybody, because it's.
Yeah,
that
so
is-
that's one of the benefits we have seen,
okay.
is this eliminates having to tell your story to
Over and over and over.
10 different people in law enforcement. We have just this one video. I mean, granted, so if a detective goes into a situation and they're like, okay, I think we're gonna need a forensic interview in this, they will get this much information and then they'll contact me and say, hey, when can we do an FI? And I'll say, okay, let's do whatever day. Like, I actually have one at 3 o'clock today.
We're trying to get her
So
out.
I do need to leave here in just a sec. But yeah, I hope that that kind of answered your question. And watching the interview live is only the detective. Sometimes we have prosecutors watching, but that's if it's a pretty high profile case or different things like that. What was I gonna say? I can't remember. Anyways,
We did have a comment in the chat. I know that in some cases, child forensic interviews can be used in place of a personal testimony at trial to protect your child from. Oh, Christy's saying no.
I can take, yeah, so
I fully read though.
unfortunately, for both forensic and child interviews, we still have to have the victim testify at trial. While we can use those to help, but you still have to have them show up to trial. So in an ideal world, that'd be great if this would replace, but because of the confrontation clause, we have to put the victim on.
For children, sometimes in prelim.
Yeah, prelim, that's a good point. Yeah, prelim, there are ways we can use the video at prelim.
and I don't think we really do the video at prelim for adults. Because as awful as this sounds, it's easier. It's never easy to testify, but it's different putting a kid on the stand versus an adult. And also we do have the option to do an 1102 statement, so they can write that down, where a kid can't write down typically what happened. And so, but we don't utilize the interviews at trials or adults. I haven't seen it at a prelim. So
That, there is a second piece on there. Are there efforts to expand adult forensic interviews to the rest of the state? And if so, how do we support that effort?
So I'm trying to figure that out. Send me an email, because me and my boss, yeah, my email's up here. So I work under Chief Terry Taylor. He has helped guide me through this as well. And I would love to help expand this because I have seen such a benefit. So send me an email. Let's brainstorm, collaborate, try to figure out a way to expand this.
I apologize if I missed this, but if they're working with a community advocate, can their advocate go to the forensic interview with them?
That's what I was gonna talk about. So in the interview, we do not want to have anybody in there unless they will not talk to us without somebody there. We don't want a mom, we don't want an advocate, we don't want a sister, we don't want a friend. We just want it to be me and this person, because we don't want them to influence anything. Not saying that they would, but we don't want them to be like, so say the victim is here and change or alter something that really happened because they don't want this person to know, or they don't want them to whatever. So we have just kind of made a policy in our office that it just doesn't happen. They can come to the interview with them and they can wait out in the lobby. But we say nobody in there again, unless they refuse to have an interview and talk to us, but then we'll sit down with the advocate or whoever it is and give explicit instruction. And if it gets to a point where it's like, you gotta get out, I will be the bad guy and say, hey, you know what, this is not appropriate, I need you to leave. So. Any other questions?
And thank you, Cass. We'll get her to her forensic interview. She has at 3 o'clock. Okay, so we just wanted to touch a little bit. We talked more than we thought we were going to, so I'm gonna go through these a little faster, but we just want to talk about juvenile cases very briefly. Because the juvenile world is so different, just being aware as advocates that the rules are a little bit different in the juvenile context, just to be aware of what's going on. Obviously, within the juvenile world, our purpose is gonna be rehabilitation and accountability. That is what the juvenile world focuses on, and that is what kind of everything streams from. They're different because of the age. Most of these hearings are closed to the public. There's different verbiage that's used. I think when you're explaining to victims about resolution, it is an adjudication versus a conviction, and just little things like that. Just being aware about using the best terminology as you can, so that a victim's gonna understand that the juvenile world is a little different. Incarceration, not likely to be ordered with a juvenile case. And I know that can be so hard because we do have juveniles that are charged with very, very serious crimes. Very unlikely that you're gonna get jail time on these cases. So this goes back to that transparency and communication about not giving unreasonable expectations to victims.
So for these ones, as an advocate, because I do the SVU for juveniles, these ones are probably. All my cases are hard because I do all of the SVU, but juveniles tend to be a little harder because they are offenders doing felonies that they're not gonna get detention. Unfortunately, they're not gonna be on the registry. It's a sealed record until they're 18. So reasonably, the family's gonna be upset with you as the advocate, with you as the prosecutor, with you, whatever you're doing to support them, because they're not getting what they want as justice. So I try to be transparent on that first initial call saying, hey, just to let you know, this is the difference between juvenile court and this is the difference between adult court. I'm sorry, but you're not gonna see A, B, and C. Sometimes I get a good reaction, sometimes I'm getting yelled at. It just depends on the family, but you have to be transparent, and that's where it comes with working with the juvenile prosecutors and say, hey, this family's upset. What can I do to help you, to help me, to help them? But they still have sentencing, which is disposition. They can still have their impact statement. Like, there's still some similarities, but the big aspect is no registry and they won't be going to DT or any of that stuff.
And restitution has its own rules under the juvenile context, obviously, because these are kids. The court obviously doesn't want to be putting big restitution orders on kids, so it is a little bit more limited in what we can get restitution for juvenile offenders. So just advocates, prosecutors being aware of what those limits are, and just going back to make sure that, encourage UOVC for these cases, and just making sure prosecutors are vetting those requests and explaining why we couldn't get a certain request.
Yeah, restitution is different because it depends. On the SVU cases, unfortunately, they're usually family on family crimes, so siblings on siblings. Restitution's never gonna be on those cases. There's other cases where I believe the judge cuts it off at 15 or 14. So if the kid is under that age limit, restitution will not be ordered, but that restitution amount will be like community service. Obviously, if they're older and have a job or can get a job, then it falls on that juvenile or offender to take care of it, because at the end of the day, it's their consequence and they don't want the parents to be pocketing or paying out the victims, because it's not fair for that family to pay if it's the offender, if that makes sense.
Secure care is essentially prison for juveniles. Again, like we're saying, it's pretty unusual for a juvenile to go to secure care. Very specific rules on when you can and can't send, the types of cases that obviously has to pose a risk of harm to others, conduct that resulted in a victim's death, or there's a couple of others, but there are limitations. So just, again, those reasonable expectations that it's not likely. Just a quick tag that most of the time, if you commit a crime after 18, you're gonna get charged as an adult. With some exception, this is the exception, if something was a delayed report, but it was reported before the defendant was 21, and it happened when they were under 18, that would then come back to the juvenile contact. So our juvenile prosecutor let me know of an example where the incident happened when the juvenile was 18, but DNA results that actually helped charge the crime did not come back until later. It was, but because it happened when the juvenile was a juvenile, it did go in the juvenile context. So sometimes it can go outside. Shameless plug, just because we know that all the work you guys do is so hard. It's important to have self-care. I think that's probably a main theme for all of your trainings that you do. We know that we work with victims with a lot of different levels of trauma, and we ourselves can face our own burnout and our own vicarious trauma. So just checking in with yourself. If you're dealing with a case and start noticing that your ability to advocate for a victim is diminishing because of your own whatever's going on in your life, it is okay to ask for help and it's okay to get reassigned. In order for us to be the best advocates and prosecutors we can be, we need to recognize we might need to just step back a little bit from the case. So just remember, you're all important. Check in with yourself.
For that one, I heard that the lifespan not lifespan, I'm not gonna die, but like for a victim advocate where SVU cases is 7 years, I've been doing it 3 years. And in those 3 years, I probably took my vacation and I was definitely burnt out. And to tell you the truth, it's okay, say yes, take that vacation, because it really does make a difference. Like, not saying that I didn't give my all to those victims while I was burnt out, but I could have done a lot more, but because I wasn't mentally there for them, I couldn't help them out the best I can. So take care of yourself, don't wait 3 years.
And we just wanna end with a thank you. We know that our jobs are extremely thankless. Not that anyone got into this world for praise and thanks, but it is nice to hear a thank you. So Miriam and I thank all of you for all the hard work you do. I know I couldn't be the prosecutor I am without victim advocates. I give so much praise to every advocate I work with. So thank you. Yes.
Thank you.
Any questions? No questions. Thank you guys.
Perfect.
Thank you, for all of you. We really appreciate the information. We will take a break for the switch of our next presenter, so we'll come back at 3. So we'll take a 10-minute break and we'll get started at 3 o'clock. All right, sorry, we got started back a little bit late, but we will get going. Welcome back, everyone, from break. We are excited to hear from Christy, and again, Tony explicitly not to read her bio again. But she's the CJC director here in Washington County, and going to be talking a little bit about the CJCs and doing a little more deeper dive into the rights that children have as well. So we'll let her take it away.
And I didn't mess with the mouse, so it should still work.
Oh, technology, we love it. Hey, sorry, you got me again. So here we are. I am the director of our Children's Justice Center down here, and can I get a feel for who we've got in the room a little bit? Would that be okay? So if you are a systems-based victim advocate, will you? Okay. So community-based victim advocates? Got like a whole table of you right here. You're like in concentration. Okay, over here as well. Awesome. So we've got a mix, looks like a few more maybe community-based than systems-based, right? So and there are differences. And you heard my friends from the county attorney's office talk about what some of those differences are. And the big one is that everything that is told to us, we have to pass along, right? It's all exculpatory. Nothing that is told to a systems-based victim advocate is confidential. So just kind of keeping that difference in mind. So there are 25 children's justice centers across the state of Utah. So I know we've got at least one CJC victim advocate here. Any others? Anybody else here from a CJC? Okay.
Online we do.
Online we do. Awesome. Hi, friends. So regardless of where you are in the state, you should have service from a CJC, from Cache County down to Grand. So like I said, 25 of us across the state, but we all report to our counties. We sort of have in the Attorney General's office, there is a CJC chapter that provides technical assistance and they administer our contracts for the money that comes down to us through the AG's office, but they're not the boss of us. Most of us report to our county attorneys, some to maybe a county commissioner or something, but usually we're gonna be like a redheaded stepchild of the county attorney's office. Did I say that out loud? I actually love our county attorney's office. We've had just fantastic people there that we work with. So grateful. So what is a Children's Justice Center? So a Children's Justice Center is a home-like child-friendly facility where children who've been victims of abuse or other crimes can begin the road to healing. And we're going to talk a little bit, we're talking about advocacy through the ages, right? So we're going to cover that in a couple of ways in the next few minutes. One, I'm going to give you a little bit of history on Children's Justice Centers and how they developed. And two, we're going to talk about ages in terms of, younger kids. How are things different for kids than they are for adults? And go through the code a little bit on that. And I promise I'm not gonna make you read code. Because is there anything worse? Like Stephanie, bless you. Who wants to read Utah code? Like nobody, ever. Okay, you should also know that regardless of where your Children's Justice Center depending on where your Children's Justice Center is, there might be different services available there. Things are not going to look the same across the state at the different CJCs. So Weaver Morgan is going to do things a little bit differently than we do here in Washington County, but we all are working to the same set of standards, and I'll talk about that in a minute. So CJCs, so this is the mission of us in Washington County. We collaborate with multidisciplinary partners to protect each child, advance justice, promote healing, and educate our community. That is for Washington County. Now, wherever you're from, they might have a little bit different mission statement, or they might not have one, but they probably have one. And it's probably gonna look a little bit different from this, but have some of the same components. So let's talk about a few of the things that are different for child victims as opposed to adult victims. So this is a picture from the inside of the fridge at the Children's Justice Center this morning. We have lots of juice boxes and Capri Suns. And we also have the full range of Dr. Pepper. So, because, you know, law enforcement needs to, okay, I need my caffeinated beverage in the morning, but we also are, everything that we are doing is gonna be through the lens of what is gonna be best for the child. That is our lens of how we do business. So if there's a way we can make it easier, more comfortable, more home-like, more safe, that's what we're gonna be trying to do for kids. So, and systemically, there are differences for children. For one, children don't get to choose whether the crime against them is reported or not. Adults who have been sexually assaulted get to choose whether they report or not. But we are a mandatory reporting state here in the state of Utah, so if you know or suspect there's been child abuse, you are required by law to report it. So kids don't get to pick that. There's also the age of consent that comes into a lot of our charging decisions with kids. I'm not an attorney, so I can't speak to it entirely, but I can tell you that other than when the legislature decides to do crazy things, which, you know, I don't have any legislators here, do I? Okay, usually the age of consent is 14, right? So if children can't consent, that you don't have to prove the consensual or not consensual piece that you have with adults. So that can help our charge. Stephanie's going, yep, you're right. So that can help us with charging decisions, right? If you've got that. And honest to goodness, there's a full-on matrix about that, about what the age difference is, and if it's, you know, 13 to 17 or 13 to 16, or there's legitimately an Excel spreadsheet. So don't try and figure it out on your own. Go to your prosecutor or somebody who can figure it out. And honest to goodness, it changes during the legislative session. We recently just had a change happen that was sort of well publicized this past session, where 18 and 13 now can be a thing, as long as the 18-year-old is still in high school. Okay. Additionally, there are additional rights for children who are victims on top of what adults have. So Stephanie and Miriam went through the victims' rights really well. That was a great review of what. And no matter how long we've been doing this, I think it's always good for us to kind of review those, right? And get in our heads what those rights are. So, but in addition to those rights, children have more rights. So we're going to talk about what those are and what they look like. So this is the code. You don't have to read it. I'll read it to you. In addition to the rights afforded to victims and witnesses under this chapter, child victims and witnesses shall be afforded these rights, and here's what they are. First, children have the right to protection from physical and emotional abuse during their involvement with the criminal justice process. Okay, I think adults should have that right as well, but we have it codified for children. So what does that look like? So children's justice centers were designed to look and feel like home. So you can see the picture on the left is a picture of a therapy room for teens. And the picture on the right is our waiting room, our kind of little kid corner in our waiting room for our mental health facility. So the idea is that it's supposed to feel safe. It's supposed to be child friendly, We don't have any plants that could be toxic. We have covers on the outlets. I mean, all of the things you can do to make that space appropriate for children. We do that. And that was the part of the original impetus behind having a children's justice center that's a building separate from the police department or the county attorney's office or whatever, is to have that child-friendly setting. So we started with the child-friendly setting, and what we add to that is forensic interviewing, and we'll talk about that in a minute. So here's the next thing. Children are not responsible for inappropriate behavior adults commit against them. Thank heavens. And have the right not to be questioned in any manner, nor have allegations made implying this responsibility. Does that happen? It can, right? We do our best to make sure it doesn't. Those who interview children have the responsibility to consider the interests of the child in this regard. And so you will find that most children's justice centers have moved to having a dedicated forensic interviewer. In some places, like here in Washington County, our forensic interviewer does forensic interviews. That's what she does. You heard Cass talking about her. Her name's Brooke Triplett. She's fantastic. She does what she does and she trains other people to do what she does, and that's it. And she testifies at court. But she doesn't have other job responsibilities, and she's really good at it. So this is one of our forensic interview rooms. It isn't as pretty as Cass's. I need to get her decorator over. But everything about that room is about protecting the child. The gray couch is where the child would sit, and the orange chair is where a forensic interviewer sits. And you can't tell it, but you can see there's the one camera. There's a second camera as well. One is right in on the child's face, and the other captures the whole room. We need that legally. The wall behind the orange chair there is actually made of something called whisper wall, and it's all about keeping the sound inside the room so nobody outside can hear, and so that the child's not hearing what's going on outside. And you can see there's like weather stripping on that door. The picture that you kind of see that sunset or sunrise, who knows which, that is also, we ordered it special that it absorbs sound. It's a sound absorbing photo, big thick rug on the floor. That pillow that you can see is one of those sequin pillows. So it's can be a kind of a, not without being distracting, it can be a fidget for the child. So everything about that room is designed to create a safe space, a insulated space, and to keep that interview protected and private for that child. And comfortable. So this is where we would normally interview teens. We have another room that's outfitted for children, but you're not gonna, there will be no toys in there. There's not gonna be anything that's distracting in there. It's so that the child can better focus. So forensic interviews, we've got stuff going on top of my notes, so I'm gonna have to. Okay, so forensic interviews were the reason CJCs were invented in the first place. To do that interview that is needed for a child, to do it one time, to have it recorded, so the child doesn't have to be interviewed, as we were hearing earlier, over and over and over again. To do it in that homey environment. And originally, those interviews were done by usually law enforcement. And we have moved now to this dedicated forensic interviewer. Not every county is going to have one of those. You might have a detective or two who are designated to do it, or somebody, a CPS worker or two who are designated, but usually it's moving more toward the dedicated FI model. And why? Well, we heard about it before, right? Detectives are awesome and we love them, and they are really good at interrogating. And once in a while, you'll come across one who can be good at doing those open-ended questions like you heard about, of not leading. We never lead a child in a forensic interview. We follow a national protocol that's been vetted and holds up in court. let's see, we use the child's own terms and language, so if a child says he licked my cookie, we're gonna clarify what a cookie is, and then the interviewer will use the same term that the child used. Our forensic interviewers are trained in how memory works for children and what's age appropriate, what you can age appropriately expect from a child. Because a 3-year-old, they can say it happened yesterday, and it could have happened yesterday, or it could have happened last week. They don't know the difference, right? The investigators, like the adult interviews, watch in a different room. Only in this case, you'd have both the detective and a child protective services worker generally watching in another room. She'll still take the break near the end, check in with the investigator, see if there's anything else that they need. And the interview, like I said, is recorded. And not only is our forensic interviewer trained in, we call it FIT, forensic interview training, the investigators are as well. Because we know those investigators are gonna be doing interviews outside of the CJC for different things. And we want them to have that best practice under their belts. And they can also best influence the interviewer. They collaborate better if everybody's coming from the same set of forensic interviewing protocol. So there are investigators and across the state who have been trained in FIT. Next thing, child victims and witnesses have the right to have interviews relating to criminal prosecution kept to a minimum. We talked about that. That's why we record them. All agencies sub-coordinate interviews and ensure that they are conducted by persons sensitive to the needs of children. So that leads us into our multidisciplinary team. And this is the heart and soul of children's justice centers, are these functioning MDTs that work these cases. For a children's justice center, we are required to have law enforcement, child protective services, medical, mental health, prosecution. We'll also have our forensic interviewer there. And these MDTs work the cases together as professionals, so they're not hitting up parents and kids from all sides. So, any questions about that? Any of you have worked with your MDTs locally?
We actually have our school districts participate. We have somebody from the schools, which has been really helpful.
Yeah, some CJCs do add schools in. We also will add in GALs sometimes. So there are others who can be super helpful on those multidisciplinary teams. And this picture is of probably about 2/3 of our MDT. And we took that at the annual CJC symposium. We have it at Snowbird every May. Why do we have it at Snowbird? Because ski resorts are cheap in May. They're metals. So we go off the mountain, take our MDT and do a dinner. And it's a great bonding. And we meet with our whole MDT once a month. We have trainings, the torture presentation that we did earlier today, our MDT got earlier this week. We'll have other trainings. We have lunch together. We have CJC Jeopardy every December. Brooke Triplett is a ringer. Actually, she usually puts up the questions. Her husband's the real ringer. Anyway, so our MDTs are just this heart and soul and the core of what we do. And so key to making sure that, again, the interviews are kept to a minimum and that everybody's coordinating with each other. And that goes to that additional right that children have. Along those lines, I'm going to take a short detour here. This is a slide that I use often when I'm talking to parents and others in the public. But I think it's important for us all to remember and maybe use as we're talking in the public. So when a child discloses abuse, here are the do's and don'ts. Do listen. Do not interrupt a disclosure. Once they started talking, let them talk. but do not ask questions. And that is so hard, right? We all are just curious. We want to know. But if we don't need to know, we shouldn't ask. So don't ask questions. It can cause problems for prosecution down the line. Do not promise a solution. You can't promise a child you're gonna keep them safe because you have no control over that. So, so never promise a solution, but do thank the child for telling you. Do reinforce with the child that it is not their fault. Because they probably think it is. Do tell the child that you will report the abuse and then report it. And whatever it was that you were doing that made that child know that they could talk to you, keep doing that. Okay, next, right, child victims have the right to be informed of available community resources that might assist them and how to gain access to those resources. Law enforcement and prosecutors have the duty to ensure that child victims are informed of community resources, including counseling prior to the court proceeding, and have those services available throughout the criminal justice process. So the CJC services that we provide are all about that. So we have system-based, as we talked about, victim advocacy. We'll do some crisis intervention, and we will connect families with resources in the community if they need resources for food or resources for housing or help with a letter to an employer or child protective orders. We can do all of those things. We have a medical team here in Washington County. Our medical team is located at our CJC. Some of your bigger CJCs, other than Salt Lake and Utah counties, have that. I think you have one in Weaver Morgan. On staff. They are actually employed, our medical teams, most of them. There are exceptions, but in most counties, the medical team is employed by Primary Children's Hospital, Safe and Healthy Families. And they can do anything from take pictures of bruises all the way through rape kits for children. And it is game changing to have medical in the building with us. It's amazing. We also will do, most children's justice centers will do trauma and suicidality screening. We use a tool that was developed by the University of Utah and in conjunction with Primary Children's Hospital. And we use those results to help show parents that kids identify whether kids need therapy in a quick screener and help parents know what their kids are actually going through. Because you can have a 14-year-old who might not be sleeping ever at night, and mom or dad might not know that. So helping parents understand what if any trauma response their child is having can be so key in helping that child to heal. And it can be key in motivating families and parents to get the child involved with therapy. All children's justice centers have some kind of a therapy resource, whether it's a referral list to trauma-informed, evidence-based providers, or some have staff therapists that actually work as part of their CJC staff. We have one. Some have contracts with therapy groups within their community. We have that as well. If you've got the money, it's a great investment. If you don't have the money, therapy is really an expensive piece of the puzzle. So, but again, having a therapist on staff and in our building has been game changing for us. It's been awesome. And then we have another therapist who comes into our building to do on a contract basis to do therapy with kids. And then we have others just in the community. So, therapy services so important. This is going to be short term. This is not going to deal with complex trauma. It's going to be short term about the immediate trauma response. It's usually 12 to 20 sessions, depending on where you are and what the funding source looks like. It needs to be an evidence-based modality. So we're looking at things like EMDR, TFCBT, child family interaction therapy, along those lines. There are six modalities that we can, different modalities that have been approved through our national accrediting body, which I'll talk about in a minute. And then we will connect our victim advocates in Washington County will then connect the family with the victim advocate at the county attorney's office. With the ones that are gonna sit with you through court. Now, if they want us to sit with them in court, we will absolutely do that. We do that sometimes. But Cass, I mean, you met Cass and Miriam, they're amazing. And they're the ones who that's kind of their bread and butter and what they're really good at. So we'll do that warm kind of handoff with the family. We check in with families. We'll text or call them after a couple of days, after a couple of weeks, after a couple of months. Just to touch base with them. The other thing that we do is, you heard Cass talk about case reviews. We will do a full MDT case review when law enforcement thinks they've got their case. And or anyone on the MDT can ask for a case review, and we'll have everyone who's been involved in that case come to the case review and talk through, okay, here's what we found, here's what the interview said, here's what the suspect said, here's, and the prosecutor will be there and usually decide right then, okay, here are the charges, or go back and get me some more evidence, or do this other interview. But usually we can get a charging decision in that case review. That's awesome. That has really helped. Once we instituted that kind of case review, it helped alleviate what can sometimes be any of you have black holes at your prosecutor's offices? Where they say, we'll send it in for review, and then what, right? And I think it's really helpful for the prosecutors to have all the people in the room who know what's going on, give them the case. And our mental health folks will be there, our medical will be there. It's a pretty cool thing. So, any questions about anything so far?
I do have a question.
Yeah.
So you said something about child protective orders.
Yeah.
That's something your CJC does.
Our CJC will do child protective orders for our clients. Not every CJC will. There was a minute where we weren't because we didn't have anybody trained to do them, but some will. Yeah. Yeah. And if they don't do them, they can refer to usually a law enforcement agency, victim advocate who can. Yeah. Anything else? Okay.
Nothing in the chat either.
Nothing in the chat either. Okay, we're gonna blow through this. Okay, so we're almost done. I talked a little bit about our national accrediting body. It is called the National Children's Alliance, and they have 9 standards that all children's advocacy centers across the country should, if they want to be accredited, need to fulfill. And the book is like this thick of stuff you got to do to become accredited. It's really actually quite complicated and hard, and not all TJCs in Utah choose to be accredited. But whether they're accredited or not, whether they go through that step, that process of accreditation, they should be living up to those standards according to our contract with the AG's office. And they give us the standards for how we deal with our MDTs and information sharing and what case review should look like and who should be there and what kind of training our forensic interviewers need to have and what kind of training our medical people need to have and what kind of training our victim advocates need to have and what kind of resources we need to be able to provide. It's a long and exhausting list of things that we should be doing to be able to be providing this a standard of care that would allow accreditation. And you see it says that it's for children's advocacy centers, and you all probably know this, but I'm just going to remind you that what we do as CJCs here in Utah in 48 other states would be called a children's advocacy center. And you should also know, in case you have cases that cross state boundaries or whatever, that there are children's advocacy centers across the country, and you can find out where the nearest one is if you go to the National Children's Alliance website. But they're all going to look different, and just like, I mean, here every county is going to look different because it's going to be responsive to their community. We're a prosecution-based children's advocacy center, and all the ones in Utah are, but outside of Utah, a lot of them are standalone not-for-profits. And you might have one here And in Pittsburgh, and I'm just making this up, I don't know what Pennsylvania's is, but in Pittsburgh and a different one in Philadelphia, and they may or may not talk to each other. Right, so they might not have the same kind of coordination that we have here in Utah. Here in Utah, you can tell me your county and I can tell you who your CJC director is. And we talk to each other frequently. It is rare that I have a week that I don't have a Children's Justice Center director from somewhere else in the state emailing the group or me asking for pictures of your interview room. I got that one this week. I had a phone call as I was walking in today. I hear you might know somebody who can help me set up a 501c3 so we can have a friends board. Can you give me the name? We do that all the time. And it is so wonderful to not be doing this work alone. We have CJCs in the most far-flung places you can imagine, Grand County and San Juan County and Duchesne, and I mean, some of these folks working in these rural areas, Kane, we have a CJC in Kane who has one person who works part-time there. They're doing it in so much alone unless we have this network, this fabric across the state of people who can back each other up. I think that is one of the number one things that can lead to longevity in these jobs. Is if you have, and hopefully Swavo provides that for some of you, that network of people across the state who have your same kind of tender heart and your same kind of strong stomach that can take these cases and see these victims and work with them through the most horrific parts of their life and have those victim advocates keep going. You need to have people that you can reach out to for resources, for I just need to vent, for whatever that is. So I hope you all have that. If you don't, please find that community. And I know that the folks at UOBC are chomping at the bit to help you do that and can help you if you've got a specific thing that they've got fingers all over the place and they can help you connect you to the right person who can help you walk through whatever that is. So that is all I have unless anybody has questions. And the other thing I always do is put up the child abuse reporting hotline. So if you don't have that number in your phone, please put it there because you are mandatory reporters. Any questions or? Awesome. Thank you.
We'll get started so that I know we're at the end of our day, but we have such a dynamic presenter up next. We are going to be hearing from Grant Dickinson, and he is, I'm sorry, let me start over there. He's been an attorney since 2010 and he earned his Juris Doctorate at Willamette. I probably slaughtered that. Okay. University. He's previously was at Provo 4th District as a clerk on their domestic violence team. He's also named Appellate Attorney of the Year in 2012 by the Parental Defense Alliance of Utah and was recognized as a top attorney in 2020 to 2025. I cannot read today. In criminal defense and divorce law by super lawyers. He practices in family law. So he's doing divorce, custody, disputes, child support petitions to modify orders to show cause, contempt, interstate child custody cases and appeals. He also does child welfare cases, termination of parental rights, challenges to administrative findings by DCFS, state removal of children, reunifications and appeals, and then also does criminal defense of DUI, drug possession, child abuse, theft, retail theft, assault, witness tampering, and impaired driving. So really just has so much, a wealth of knowledge, and we are just so privileged to have him here and so grateful he was able to come down and present, and we'll let you take it away. Yes, and he said he has a dance number for us, so.
Right. Yeah. If I can get my music to work, it's actually really important to my presentation. I don't know,
as far as like camera goes for the folks that are online, where this one,
Guy, so when you were up here.
that guy, will it track me?
Yes.
Oh, that's wicked awesome. All right. Well, thanks. We can talk about that. We can talk about stalking. Well, like I said, like she said, I'm Grant. I wasn't on the domestic violence team at the court. I was on the domestic team. If I played domestic, I could have said it. I don't know. I realized I cut and pasted a lot of that. The laws have changed. There's no orders to show cause anymore. They're all motions to enforce. Anyway, doesn't matter. I want to start and get you all up on your feet. Everyone stand up for me. And some of you will stand up longer than others. Even if you're online, stand up. I got to look at the owl there. So, all right. Now, those of you that have been victim advocates or worked in the victim system, I don't know if that's the right phraseology, but who have worked with victims of domestic violence for more than a year, keep standing. Those that have less, go ahead and sit down.
It's her second day. So.
Oh my goodness. Welcome. Welcome. But what about those that have been more than 2 years? Keep standing.
No, she's gonna make me go.
More than 5 years, keep standing. Wow, no one's sitting. All right, more. Let's go 10. Let's go big one. 10 years. That's a great crowd. Look, these are your mentors that are still standing. Who's done 15 years? More than 15 years. Oh, there we go. We lost a few more. More than 20. I'm gonna say 25. 25? 25 years, saying 25, 25. 30, 30, going 30, 31, 32. Thank you. Give them a round of applause. I know, let's see, which one do I click when I click on this?
The forward.
Like, oh yeah, you've done this before, huh? Yeah, right. I guess.
I might have just lost our mouse. It just likes to do that. Okay, it should work now.
So I used to be a victim advocate back in, this is 2021. Or, sorry, that's a lie. 2001. So in 2001, at Orem City, I was a victim advocate. So it is something that, I mean, that's where it started for me as far as like being involved in the law. That was my first job, like got me into the courtroom. Back then, we used the term gaslighting differently than the Dixie Chicks use it, right? Like it's a little overused now, but it wasn't. But it was a great opportunity, got me into court, and I just really learned that I love the courtroom, and it got me in with individuals who were victims of domestic violence. I get to talk to them, got to talk to the prosecutors and communicate what they wanted to have happen, and what a great opportunity that is, and what an important opportunity that is for people who have had very, very limited voices, and in the relationships in their lives, get a voice through you. And I hope you know that while I'm the defense attorney and like the hated one here today, you guys can ask me any question you want. I'll tell you right what I feel. But I hope you know that what you do is really, really important, and I recognize that. And I still get to do that from time to time. The Utah County folks, I work with them all the time, and I do victim representation. And we see a lot of each other in Utah County. So, and sometimes I'm on the good guy side, and sometimes bad guy side. Sometimes you can't tell the difference between the good guys and the bad guys. It's just is what it is. So anyway, I wanted to let you know that I'm not totally oblivious to what victim advocate is. I don't know if I broke something already.
No, it's just our owl.
Hopefully can they still hear me online?
They can still hear you. They just can't see your.
Oh, they're lucky. Sorry, y'all.
Your face right
You guys
now.
here in person have to deal with me. Okay, let's see if I got this right.
Yeah. Oh no, I messed you up. Sorry.
Oh, I don't know if it's quickly working.
It is. It's just me.
You're just watching for me to hit the button. You're like, oh, there you go.
Yeah.
So where I want to start is kind of this intersection of our three courts in Utah. Well, I say three courts. It's a little bit kind of a conglomeration, right? We've got our family court side. That's where we're doing our divorce and our all of our paternity cases, child custody and support cases. That's where they're at, right? We also do a fair amount of protective orders in there. And in criminal court, obviously that's where we're getting criminal charges. We do a fair amount of protective orders in there. And we heard a little bit ago from our CJCs about juvenile court, and there's a lot of protective orders in there. That is usually where my practice comes in like at my office, we have 9 attorneys. And anytime any one of these cases has a protective order, they call me. And some of that's because of my background, right? I was at, I worked with probation in the juvenile court. Oh, did I do that? I'm sorry if I messed that up.
No, it's me.
Okay.
I got you. 1 second, sorry.
You're good.
Our Al just decided that he was done for the day.
Oh, you know what? I get it. Hope you're not done.
We're not.
Hang in there with me. If I talk too fast, I'm sorry. You can, any questions so far? Wow, we've talked about a lot right now. No. I gave it a workout, right? I started moving left to right. How I was supposed to go all the way around, you know? Question in the back. Doll, give it to us. Oh, I do every aspect of its protective order. You bet. I have represented victims or petitioners in protective orders. I've represented children in protective orders, like in child protective orders. I've been a guardian ad litem several times. And the county calls me and says, hey, we've got a conflict. Do you want to represent a couple of kids in a protective order case? And I said, sure. Right. The county, like, oh, well, Casey bore the cup in Salt Lake now. It used to be the county. Now it's the guardian ad litem's office. So I represent respondents, petitioners, and children in any of these aspects. So I've been on every side of a protective order except for being the guy in the road. So I don't really want that goal. That's not for me. How we doing?
We're okay. Yeah, we're getting it.
So that's generally where I get involved in any of these cases, is starting with protective orders. And we'll go on to the next slide. So I want to talk a little bit about in order. And there we go. So first in the juvenile court, and you guys may already know this. Sometimes the CJCs, and I love the CJCs too. If you haven't taken a tour, go take a tour. And that slide about what to do when someone reports abuse, follow that to the letter. All right, I'm a criminal defense attorney, right? When I watch interviews with kids, I'm watching for all the wrong ways that people ask questions. Right? There is a modality to it. Follow it. If you are not trained in it, get somebody who is. Right? Follow exactly what she said, and then get somebody who's trained to do that interview. I don't know if she had this at the beginning of her presentation, but one of the rights that we often talk about
There he is.
He's on. One of those rights that our kids in Utah County that we try to protect is to have the least number of interviews. And I'm going to talk about why that's important as we go through. But when we talk about juvenile court and child protective orders, that's where they generally start. Now, child protective orders can go to the district court under special circumstances if there's a pending other domestic case, a divorce case or a child custody case. If that's still pending, the juvenile court judge can send it to the district court. Okay, but generally the juvenile court judge will get these and they will review it. And they're looking for really two things. They're looking for physical abuse or sexual abuse. All right, that's what has to be alleged in a child protective order. If you're alleging, well, you know, dad called the daughter names, that's not enough for a child protective order. Okay, even if it's a push and shove, that's not enough. Has to be child abuse. Okay, easy rule for child abuse, right, is you're making a lasting mark. Right, which can be kind of hard if your children are very pale skinned and you squeeze their eye. Right, you can leave a lasting mark a whole lot easier than you can on somebody who's maybe darker complected. So that all goes into it, not to mention the fact that if it's a parent, they're going to talk about reasonable discipline and why in this moment that was reasonable. But what we're looking for again is child sex abuse, child abuse, right? Lasting marks. That's going to be your grounds for the entry of a child protective order. Will judges give child protective orders on grounds that aren't those? Sometimes. Can you get a permanent one on that? Yeah, sometimes. If you can kind of get the judge to go your way. Should they? Probably not. The statute's pretty clear, but there are some broadening languages, and the judges can sometimes be generous in trying to protect children. The great thing about it is you get a guardian ad litem appointed in these cases, and they're doing an independent investigation. And it's great when you have a guardian ad litem who gets down and talks to the kids, goes to the kids' homes, talks to both parents, and is really doing an independent investigation. That makes a big difference in not only short-term outcomes of what's going to happen with the child protective order, but that they can make a credible recommendation as to how this family needs to move forward, right? I say very flexible rules of evidence, and they are. Man, the rule of evidence in child protective orders is that anybody with information gets to talk at a child protective order hearing. That's the rule under the Utah rules of juvenile procedure. Anybody with information. There's hearsay, oh, we don't care, bring it in, right? Anything. Everything comes in a child protective order hearing. So these are great for getting the judge information. Another thing that you've got in juvenile court are all the resources that juvenile court has. It's not uncommon for once a child protective order is filed that DCFS will get involved. And DCFS has a lot of resources. They've got some counseling that they can do. They can put in safety plans. They can connect the parents with counseling and parenting programs. So those are some of the advantages that are in child protective order land or juvenile court. The one limitation is that they're generally limited to 150 days. They're short term. Okay, these aren't intended to be long term, but that may be a good thing, right? It may be that, hey, we just need to deal with this acute incident. Now, I say that knowing that there's a cycle of abuse and acute incidents, like, oh, of course, everything's gonna be great right after that acute incident, right? And we don't know how long that cycle is unless we've been in it. And so hopefully those that are involved in the juvenile court can be sensitive to that and they're not forgetting that cycle of violence. And maybe that's where you come in. Maybe if you say, hey, you know what, this has been out of every 4 months, or maybe it's only been every year. So we need something that goes a little bit longer, or we need some treatment that will have some expectations that are a little bit longer than 150 days. And the courts have some flexibility on that, but it's somewhat limited. Okay, certainly if this is an outside, you know, if it's Uncle so-and-so who's hit the child, then we can make that a permanent order. It doesn't have to be a 150-day order. 150-day orders is usually when we're talking about parents. We've got one parent who's being a restricted parent, who's the subject of the protective order, and you've got the other parent who's requesting it. Those are generally gonna be 150 days. If you're looking for a longer type case, you've got to come in and bring in DCFS so that you can do a child welfare case. Or we've got to be talking in the divorce court about how that we're gonna have that long-term plan go forward. Now, obviously, the divorce court, we're looking at 2 separate homes and we're looking at a lot more complications. Child welfare side is great for when we're looking at bringing those homes back together. If we're looking for kind of maintaining a long-term relationship and educating all parties about the abuse and helping them get treatment for it. But if we know we're getting separated and we're getting divorced, maybe just throw it to the divorce court. But juvenile court's better equipped for certain aspects, divorce court's better equipped for other aspects. So work with, you know, the teams that you have in determining which route is the best way to go. So that's it for child protective orders. Any questions on child protective orders? You can get one immediately, right? Well, not immediately, but you can go and file one today. The judge could, you know, what is it? Certainly I've gotten them done and filed them and had them signed by the end of the day. So if you file it right now, you could probably have them by the end of the day. Now, probably is a strong word. By the end of tomorrow, certainly. The judges generally look at those every day, in my experience, and they will have an answer for you within about 24, no more than 48 hours. And then they have to have a hearing within 21 business days. Okay, so it's kind of this short-term deprivation, which is kind of a big deal, right? Imagine if someone got a protective order against you and said, hey, I'm keeping your kid for 3 weeks. Or longer. I guess it can be up to 4 weeks, depending on how holidays land and the number of business days and how that particular judge interprets it. It can get a little bit messy. We got a question?
We have an online question for Christy. Do they expire when the child turns 18 if it is a permanent child protective order?
Right now, yes. At that point, the child can then go to the district court and get a longer term one, depending on the circumstances. But yes, right now, my understanding is that there aren't any that extend beyond 18, and that's because the juvenile court jurisdiction ends mostly when the child turns 18. They can maintain jurisdiction in certain instances of child probation and following up with children in care, but generally ends when the child turns 18. I would ask that individual if I answered their question, but hopefully I'll give a thumbs up. Yeah.
Yes.
All right.
Think that, yeah.
Do I just click on this one?
Yeah.
To make it move? Maybe.
Maybe it's
All right.
very good.
I know that looks like a repeat slide. It is. But that's because I wanted to, okay, we're going back, we're zooming back out, and then we're gonna go to criminal court. Criminal court usually starts when someone's getting charged or arrested. Okay, in Utah, when there's an incident of domestic violence, the police are
it's almost a mandate, like 100% mandate that they have to arrest somebody. Cause they don't, I mean, historically, why that exists, obviously, is because the police would show up and everyone goes, no, 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 I don't want him, or I don't want her to go to jail. We're gonna be okay, leave us alone, don't charge us. And then there's another incident. Right, and it's generally more acute, like you called the cops on me, right? I mean, as victim advocates, you've probably seen it. If not, you've heard war stories about it. Okay, that used to happen, all right? And it's been, it's probably been 20 years since they put that law into play. And it's been a good thing. For the most part, it's hard. It's really hard because we're arresting people and we're taking them to jail. But it has curtailed repeat calls to the police, repeat one night events. And hopefully maybe even save some lives. But when that person goes to jail, before they can leave, they sign a jail release agreement. Okay, which is an interesting thing, like, it's called an agreement, but if you don't sign it, you can't leave. So, a little coercive, you know, and a little duress, like, there's a contract issue there, but we're not talking about contracts. We're talking about the jail release agreement. You sign that I won't make contact with the victim, that I won't go to the victim's house, that I won't go to the victim's car, and I won't talk to the victim's kids. And, you know, 99% of the time, I won't talk to the victim, who's my wife. I won't talk to the victim's kids, who are my kids. I won't go to the victim's house, which is my house. I won't touch the victim's cars, which are my cars, right? So it's a little bit complex, but we say, hey, you know what, work it out with the judge, right? That's, you want to leave jail? Great, this is your ticket out. If you don't want to leave, that's cool. You don't have to sign it. You can just hang back there until you see a judge. But they're usually replaced at that first hearing, okay? The jail release agreements are good until that first hearing. Now, before they can be replaced with a protective order, the prosecutor actually has to file charges. If there are no charges filed, they can't turn it into a criminal protective order or pretrial protective order. So if there's somebody that you're concerned about as a victim advocate, you see the police report come in, you make contact with the victim's like, yeah, I really need some protection. Or you as a victim advocate say, hey, prosecutor, you need to look at this and probably need to get charges filed so that we can get a pretrial protective order in place. You need to, you know, be proactive on that, obviously, when that comes in and is part of your assignment. So that at that first hearing, the court does have the option to extend it. They can extend it 24 hours, right? But that just means they're coming back the next day. That buys the prosecution a little bit of time to finalize those charges. All right. And then it's converted into a pretrial protective order. And then ultimately they can even continue through the case and become a sentencing protective order. These are really great when incidents occur between two unrelated parties. Right, if they don't have to interact with each other ever again, it's great to have that protective order that gives you a little bit more peace of mind. I mean, I know at the end of the day, they're just orders and they're just a piece of paper, but it is a lot of peace of mind. And it's nice that, you know, if that person comes around and doesn't obey the order, you can call the cops and they'll be hauled away. Right, that's a little bit of relief, a little bit of high level insurance. Okay, so that's the process there. I won't go through a few of the pros and cons, right? Pros, quickly obtainable, like, you know, you're arrested, you don't get to leave unless there's a JRA. And generally before that JRA expires, you're looking at a pretrial protective order. That's a great thing about it, right? The next thing is it can last for a long time and can even go forever, right? Continuous protective orders are available, right? And the judges in domestic violence cases can and do routinely order these, right? They're free. That's the best part, right? You're not paying any attorneys. Dirty attorneys, I tell you, they're the worst. If there's any online, any in here, don't raise your hand. No, they're free, they're great, and they've recently changed it. This is a new change, that they can actually order the defendant in certain instances to pay certain utility bills. Certain needs can be ordered to be paid by the defendant. It's really narrow, and that's good that it's narrow, right? And so you can work with that just a little bit, right? The cons are there are instant ramifications. This person is now being removed from the home. Calling the cops on a spouse is a big deal, right? For a lot of people, that's line in the sand type talk, right? And that's when we're talking divorce, it's a big deal, right? We're changing people's ability to work when they get arrested. I mean, if someone works in, maybe they're a police officer, they're working with something with national security, maybe they're an armed security guard. Maybe they're anything that has to do with firearms. If you're arrested on domestic violence and you're signing a jail release agreement, good body of firearms for a little bit, at least until the case is resolved. And so that's huge. Question?
Yes, could you speak a little more to the can order defendant to pay some bill? You're not talking about a JRA. you're talking-
No, not in the JRA, you're right,
Okay.
in an actual protective order part. What's that?
Sorry, can you repeat that?
Yeah, so the question was, can, in a JRA, can the defendant be ordered to pay bills? And no, the JRA is very, very simple, and usually it's three things, you're like staying away from the residence, you're staying away from their vehicle, and you're not contacting them. Okay, but it's usually very short. And the victim can actually come in and waive those, they can waive those terms. So the JRA gives a lot of flexibility to the victim if they know how to go through the proper channels. Changing a JRA, I make it sound easy, right? Who knows how to change a JRA? Like, ask it, okay, there's like one person in the room, I just did this last week, and you know how hard it was to find the right person for the victim to go to and sign off on it? Cause there's one person at the police station that can accept the waiver, right? And they have to find that person, and the victim has to be willing to go there. Yeah, so it's not as, I make it sound easy, it's not always easy. But yeah, so we talk about that, instant ramifications, and it's long-term ramifications, right? And that can be a big deal. If your victim wants to stay with the abuser, which never happens, right? Yeah, of course that happens, right? They've got longevity, they've got history with that individual, they love that individual, they've got children with that individual, their finances are intertwined. They've got a lot of reasons why they don't want that individual charged. A lot of reasons why they want that individual home, and they probably don't want to get in more trouble with that individual as well. Got a comment in the back?
So are you saying in a criminal protective order, you believe that the bills can be ordered to be paid?
In very narrow circumstances, utilities, it's like necessaries of life. If I didn't make that clear before, it's very narrow, right? Yeah, I mean, technically under the whatever else the judge wants provision that's in the protective orders, they could do more, but generally they're keeping it very narrow. Yeah, yeah, and we're gonna talk about the more robust ability to do that in the regular protective orders. Another question in the back?
Give us an example.
An example of what can be ordered to be paid?
Yeah, you said it's under a very narrow scope, and I
Yeah.
haven't seen.
Utilities. Utilities, and I think it's on the newest forms. So check with your judges if they have the newest forms of the criminal protective orders. If not, they can put it in the whatever else the judge wants. Right, they can include that in
That
there.
says other orders.
Yes. So they can include it in there, and again, it's very narrow, and it's something that was just recently added.
The other thing I've seen is like that the defendant and the person that's against can come and get their property, they can
Yes.
specifically write that in.
Right,
as
they
well.
can, yeah, and then,
How to get their property.
yeah,
I just
Yep.
haven't seen, but they're usually with bills, the other separate.
Right.
Separation form that, but.
yeah, it's there in the law. There's one provision that says the court has very limited ability to order the defendant to pay certain expenses. And it's limited to expenses that they were already paying. We're talking telephone bills, power bills, mortgage, car payments, insurance. What they don't want is for them to enter a protective order and they say, fine, I'm not paying anything. Right? That puts us more in a financial, so this is to kind of just cover that gap. Like if we're basically taking the breadwinner out and not giving him motivation to, and I say him, right? I'm using stereotypical language. Hope no one's offended by it. Our one man in the room, sorry. And we all know that these stereotypes do bear out, and I apologize if anyone's offended by the use of him as the abuser and her as the victim. But as we go through like that, it just kind of, it bridges that gap just a little bit. Where before there was no bridge, right? We're trying to get better at this as we go along. I mean, 25 years ago. I'm trying to think when we started protective orders. No, it's more than, no, I think about 25 years ago, they didn't exist except for as restraining orders. And then we made it part of the statute, create protective orders, and here we are. Right, we're still growing into it still. Anyway, yeah, so there's limited contact to deal with just the things that come up, like, you know what, there used to be two people to get Johnny and Julie to their soccer practices. And now, you know, mom is having to do all of that, or dad having to do all of that, because mom or the other spouse or the other parent is excluded from the home. Or excluded from contact with the children, particularly when it's a domestic violence in the presence of a child. That's when they're gonna be excluded from the children. And those children hate that, right? Maybe not all the time, maybe sometimes they're relieved. but they still love their parent too, so it's hard to deal with all of those emotions, and these are blunt acts, right? This isn't surgery, this is no contact, or, you know, very limited contact. Yeah, they rarely deal with parent time. Most of the judges are saying no contact, and man, I'm having that fight all the time with judges. Where I've got a criminal protective order that limits my client's time with their child, or actually just says they can't have any time. And there's no mechanism right now in the law to get a hearing on the merits of whether or not they should. And obviously, there's constitutional implications there, but that doesn't matter. That's not what we're working on. We are talking about just, those are jail release agreements, criminal protective orders. They can go on throughout the entirety of the criminal case. And then obviously turn into sentencing or continuous protective orders at the end. And you guys, this is probably the area you're all most familiar with, right? This is what you guys would deal with way more than I do. So occasionally I get involved in this part, but very rarely. So usually it's just kind of making adjustments to them so that they can be consistent with the district court orders. And that may be one recommendation I have on this is, as you work with these, if you know there's going to be later orders, when you put no contact, you can add in there no contact except for as permitted by the district court in either a civil protective order or in the divorce case. So that way you're not having to go back to the criminal court all the time and make adjustments. And then that allows the other courts to kind of do some refinement on it, or no contact with the children except for as approved by the judge in the domestic action. So you can put that in there right now, so they're not having to constantly go back and forth. Any questions on criminal protective orders? Most of the time, as a criminal defense attorney, I don't care about these because I know they're coming in. And the judges just routinely do them, and there's no, that's not on the merits. And it's, so that, and if my client's gonna come in and enter a deal, like, I know this is gonna come in and stay in as long as the judge and the victim and the prosecutor kind of want it to happen. So there's not a lot I can do to stop these. And they're not worth any effort on that, except for in changing the parts as to the children. That's where you can make some modifications to these and actually have a constitutional argument and have an impact on these as a defense attorney. All right. Let's see. Oh, yeah, that's a good point. Thank you for my slideshow, whoever put this together. One of the things that I think is really interesting about these is they can be ordered and remain in place over victim's objection. How many of you have had victim clients come in and say, I want it dismissed? And how many of you have had judges say, not gonna do it yet? And how many times has that, as your victim, 6 months later, then, holy cow, I'm so grateful I had that added time. And so, I mean, this is where you and your profession and your experience and your training get to talk to the victim and say, hey, prosecutor's not gonna agree to dismiss it right now. Here's a couple of reasons why. And, you can connect them to resources, and hopefully they can see like the benefit of having some space when there's been an abusive incident or where there's been a long-term situation of abuse. Like we talked about before, violations are criminal charges and it's an instant arrest, it carries someone away, right? We like that part. Generally pretty easy to enforce, but again, it's a blunt axe. They don't have a lot of flexibility. Let's see, and yeah, this can be good or bad, and they don't deal with parent time. So those are just good or bad. These facts about criminal protective orders exist. And so just know when you're working on those, you can put in some flexibility or assist the prosecutor and the judge and your victim to input some flexibility so that you don't always have to go back to the criminal court. Because as it stands right now, of these orders, whichever is the most restrictive is the one that's in play, right? If the criminal protective order says no contact, even if I have one from the domestic court that says, hey, we can hold hands and make phone calls, it doesn't matter, because that criminal protective order is the one that matters. Whatever is most restrictive is the one that rules. Okay, now, as a criminal defense attorney, I'm always gonna argue ambiguity. Okay, but I'm gonna be telling my client, follow the most restrictive one. Why? Because that's good legal advice, right? And it's generally what the courts do, and that's what the courts will tell them. If if a judge becomes aware of multiple protective orders, they will generally instruct anybody who's involved with protective order, the most restrictive protective order is the one that governs your contact. Okay. All right, see that same slide again, because that's where we're going into family court, right? All right, generally, these have the same protections as outlined in the criminal protective order, right? I can get all the same benefits. And it's still a court order and it's still a criminal ramifications, but I got a lot more, right? I can provide mechanisms for, contact to facilitate parent time. I can say no contact except for at exchanges, right? I can say no contact except for through the Our Family Wizard app to arrange parent time. No contact except for through texting to arrange property distribution, right? So that gives us a little bit more flexibility, and we're already in front of that judge or commissioner anyway, frequently in the domestic case. So these aren't overly difficult to modify. And generally, when we're talking about these, both parties have an attorney, and so the attorneys can kind of talk, submit an agreed upon order, and then have the judge adopt that order to make appropriate changes. Unless you're in Salt Lake, then you have to have a hearing. Is anyone here from Salt Lake? We have to have a hearing on those protective orders, right? All right, it also can allow for contact and for mediation, which is great, because then you can get the divorce and all the other stuff resolved. Cross your fingers. Provides parent time. What's not on here? Oh, there it is. It's the top one. It's on there. Child support and spousal support. Okay, not often argued. Now, there's specific rules in the protective order that you have to do before you can get that granted, right? It's providing the financial information. Okay. And let's see, anybody here that actually works at the courthouse? No, all right, I'll just ask generally, how many of you guys have ever seen support awarded in a protective order?
Very rarely.
Very rarely, right? Yeah, like 1 in 1,000. Yeah, I mean, I've probably had 3 or 4 of those where the courts actually ordered that, because the court's like, hey, this isn't our normal modality. We want you to come in through a temporary orders hearing so we can look at all the financial information and make the call as best we can in a 20-minute hearing as opposed to a 5-minute hearing. All right, I know that I've got more on this, but any questions so far on civil or domestic? Everyone knows where to find these, right? You all know where to find these. And it's the new paperwork, is that what they call it?
My paper case.
My paper case.
I think.
Used to be OCAP. That was so much easier to say and remember. But anyway, I've got that on the slide here. If you haven't walked through that process, if it's your second day, walk through that process. All right, you can't file anything through there. You're not gonna make a mistake and accidentally file anything, but walk through so that when you're going through it with a client or with a victim, you know what's there. Okay, man, I like the OCAP one better, just because that's what I was familiar with. It's so much easier to change too. Oh, and hopefully you all know how to like change text in PDFs, like pay the extra money for some kind of actual PDF editor. So that even when you're like, oh no, I don't want to go back into the system to answer the questions the second time, you can just go in and make changes through the PDF editor. That's the way to do it. But then you also got to make sure your order is consistent with your request. So double check everything and have somebody else look at it too. Right. Make sure it's the same on every spot. Yeah, some of the things that you want to watch out for, we talked about conflicting orders, right? You think you're like, oh, I've got this order and it's great, you know, it allows for dad to have appropriate time with the kids, but there's also appropriate communication. But it obviously, if you've got a criminal court order that says something differently, that's gonna put a barrier on that. Just make sure you're not overlooking gaps. I mean, you're trained to see these, right? We're trained to look at this situation and go, all right, what does my victim need? Even though they may not know they need it. And be able to explain why. Hey, we're gonna do written communication. Right? I know we can put on there that they can have open phone calls. We're not gonna do that, right? Depending on the situation. What we wanna do is we wanna make sure that his communication and her communication are in writing. Because sometimes there's false allegations about what was said. Sometimes we don't remember what was said. When we don't remember what was said, it's always great to go back in the text log and be able to see what the exchange was. So be able to explain that to the victims as to why you're asking for that. And I mean, as a defense attorney, I love evidence. And so I mean, those text messages are great. And it's generally good for everyone. I use that when I'm representing petitioners too. And people see dumb things in text. You don't have, no one in this room does. But man, I can't believe some of the things that I've seen in text that we use later. I've had protective orders entered based solely on what's in text messages. So we love text messages. But make sure that you're covering their gaps that maybe they have blinders on for. and help them out with that, help them know like, hey, we've done this a little bit, this isn't our first rodeo, let me tell you why. Just watch out for non-safety related needs, mostly I'm talking about finances. Right, if you can cover that in the protective order, or if you can get them access to a car, if you're, those types of things, and if you're looking at, hey, I need help getting the kids to all their practices, write that in there. Right, dad can come and get the kids for practices, mom can come to the house to pick up Jenny to take her to dance on Wednesdays. Write that in there, these are, you can write anything well, not anything you want, but generally, so long as it's agreed to, the judges will approve these. They want these parties to be safe, but workable. And don't overlook children's needs, make sure that, when we talk about getting the practices and things and getting parent time in there, that's gonna be important to the kids. Even though we may think this particular parent is a bad person for being an abuser, those kids still love that parent, even if it's supervision. We're getting supervised parent time in there and those types of things. We can get that in these situations. Also, I don't have it on here, we can get a guardian ad litem in certain instances in these. Right, if you ask for it and the judge approves it, get a guardian ad litem, why? Because they're free. It's like having a free investigator come in and they come in with a lot of authority and credibility, right? They are non-biased, they're for the kids, they're doing their independent investigation, and they get access to ECFS records and investigations that no one else can get. Hey, anybody request ECFS records? Yeah, like how long do you, okay, no one raised their hand if you guys can't see online. The owl didn't pan the room. But nobody raised their hand. I request DCFS records on a daily basis. I'm waiting 6 months right now to get them back. Since they've gone to centralized return, I mean, it's a little bit frustrating and it's gonna create a due process issue. Again, constitutional stuff, we don't need to worry about right now. We got one more slide on these. There we go. There it is. That's my paper. That's the link. If you didn't have it, it'll be in the slides. Oh, I wanted to talk to you a little bit about when we fill these out with our clients. We talked about telling the story. Okay, and it's easy, right? Beginning, middle, and end. You wouldn't believe the number of protective orders I see that have, nothing. It's like, well, he hit me, I need a protective order. And sure, most of the time, somebody hitting another person, that's gonna be assault, that's gonna be considered part of the domestic violence statute. Right? But it's a way more effective if you can say, on Thursday night, we were having a fight because I wanted to sign Johnny up for baseball, and Dad said, no, he wanted to be in a club team, not in the rec league. And he was really emphatic about it, and I didn't want to pay the club team costs, and you tell the story, right? So that you want that when the judge reads this, you want the movie to click on in his brain, right? And he can see that, the movie playing about what happened. They're having the argument about baseball, right? He got mad and picked up the baseball and threw it out the window and broke the window, right? Well, guess what? That's property damage, right? Used to be called criminal mischief, right? You do it in the house with somebody around to intimidate them, that's gonna be domestic violence. Right? I don't know if that's the right issue to go and get a protective order on, but sometimes it is. Right? And sometimes you need that moment in time to just create that protective order. But yeah, that's certainly an issue of domestic violence. But if they can play the tape in their heads of what you're writing down, right? And then you gotta tell us how it ends. What was the resolution that night? Did someone call the cops? Then I had to fix the window? Is that what happened? Or he made me fix the window, or then he said he was sorry and he fixed the window, right? Talk about the resolution, beginning, middle, end, okay? That's important for the judge. It would be terrible for a judge not to understand exactly what had happened that night and not to understand that that was domestic violence. It was interesting as a court clerk, we would get fresh judges, and the judges come from all walks of the law, right? Some of them are civil judges who've never seen a protective order case. Some of them are criminal judges who have seen them in criminal protective order situations, but not in a domestic protective order situation. So our job sometimes, depending on who the signing judge was that week, is we'd have to put little stickies out to the side and say, hey, judge, doesn't this fall under this section of the domestic violence code? We'd highlight it for them. So we try to help out the judges, but you can do that too, right? You can put in there, hey, he threw the baseball out the window. Property damage statute is part of the domestic violence statute. You can go, domestic violence is defined as 76 whatever, right? I can't remember it off the top of my head. And you can say, hey, part Z, because I think there's 26 subparts of the domestic violence statute, is property damage. I don't know if that's the real part. I don't know what letter it is. If I had my notes out, I can get it. But you can cite it for the judge. especially if it's something a little bit obscure, right? If it's something that the judges don't see all the time, like property damage is pretty, they're probably gonna recognize that as domestic violence. Certainly an assault, they're gonna recognize as domestic violence, right? But what if it's an interference with a piece of property? What if it's an interference with a phone? Right? That's interference with a property. Show the judge where that's at. Maybe he doesn't think that a spouse taking another person's phone is a big deal, right? Or taking the keys to the car, or blocking a hallway. Right? Which, I mean, also in telling the story, say what happened in blocking the hallway, right? Because if it's a spouse like, hey, wait, don't go yet, let's talk about this. That's one thing as opposed to, you're not going anywhere, right? Make sure that you're telling the story so the judge knows it's that you're not going anywhere and not like, hey, hold on, can we talk about this for just a minute? Right? You've got to be able to tell that story as you're writing these protective orders and working with your clients. Make sure it's accurate. Oh, and don't forget the emotional details. How did it make you feel when he was standing over you, right? How did it make you feel when he threw the baseball out the window? Did it scare you? What was your response, right? Because that tells a story in and of itself. If I've got someone who's been through lots of trauma and has a what is elevated startle response, right? I'm getting there. I gotta get all the right terminology. But if we've got an elevated and escalated startle response, and that tells the story. I jumped, right? He threw the baseball out the window. My immediate response was to jump up or back away or to cower, right? Tell that. I was really scared. He had done this before, right? Put that in there. Make sure that you're sharing that emotion and what I don't have on here are do some observations with them. What did you see? What was the other person's tone of voice? What was in their stance that made you think that you were about to be abused? Right? Tell them what your client sees, hears, what is going on in the room. Put the judge in that room with your client. Because if you can do that, you're more likely to get that protective order signed, and you're more likely to keep that protective order at the hearing. Okay. All right, now act like a human being. Okay, you don't need to do a ton of legalese. If you're citing to the statute, great. Man, every now and then you see one where it's like on Friday, December 15th, the respondent was following me. And it's like the respondent, the petitioner, and then he stood up as tall as possible, and it's kind of like, well, that is not how real people talk, right? I mean, there can be like, hey, he was following me and he came up behind me and he was, he looked huge. In my eyes, you can put in the physical descriptions, right? They're on the front page, but that doesn't tell the court the whole story, right? If he's 300 pounds and she's 120 pounds, that's a part of the story. Include that in there. It's intimidating to have somebody bigger than you around. I mean, I don't know. Just kidding. Because I'm big. All right, sorry, that big. I apologize. All right. Yeah. Avoid these words. I'm sorry. I know that they are meaningful words, right? And I know that they have significance. Judges turn off when they hear it now. It's unfortunate. They've been overused in our society, and judges like, oh yeah, you know how many times a day judge hears gaslight or a narcissist? It's unfortunate because they do have meaning, but they've been so overused and that it turns off the minds of the judge. So be careful. It's better to describe what happened than it is to try and shortcut it. Right? Just say, he told me this, I later learned that wasn't true. We all know that's gaslighting, right? But it's better if you tell the story, let the judge come to that conclusion instead of jumping to that conclusion for the judge. Okay? Any questions on writing or requesting protective orders? Whew, I don't know what I just did. I'm the worst at this.
That's my case.
I clicked on the link. That's what I did. I didn't know that. All right. In addition to the on the request for protective order, I'm great. Can we cut that out of the video? Like, I don't know how to edit videos. All right. This is also key information. I tell you what, the judges, I think evidence makes or breaks protective orders. You don't believe the number of cases where it's like, well, Your Honor, this is he said, she said. And you can't tell what is true. And if you can't tell what is true, that doesn't mean you don't know what to do. That means they haven't met their burden. Do you know how many times I've made that argument in court? Way too many, right? So guess what? This basically invalidates that argument. You can tell what's true. Here's a picture. Cause then the other side has to explain away that picture. Right? They have to explain away a recording. Cause it exists, they can't, well, it doesn't, so he said, she said, well, except for this recording where we hear, clearly there's a struggle, clearly there's a hit, clearly there's someone crying out in pain. Right? Explain that for me. That's what the judges will want. Pictures, medical reports, other witnesses' statements, text messages. We talked about that. We like text messages, right? Even emojis can be significant. There's a Utah Court of Appeals case that talks about the significance of an emoji. Right? Like, oh, you know what? I didn't mean to send her that emoji. And then she tells the story like, yeah, you know why he sent that emoji? This emoji actually comes from an incident that happened 4 years ago when he beat me up. And then it's like, oh yeah, I can see why that emoji has significance. Right? So if there's significance to it, tell that story. Here's the text. Here's why it's important. Right? You want to be like lawyers, put exhibit A, right? Exhibit B. You can cite that in there. That's not over the top. Give the court some, hallmarks of where to find these and attach them right to the request. Don't wait for the hearing on these. Attach them right to the request. That gives you so much credibility, right? I'm so confident that these things are true. I'm giving them on day one. Protective orders, man, it's a little bit old west style in protective orders, right? You can show up the day of and bring your stuff. That police reports on them? Oh, that's disappointing. Police reports, y'all, body cam footage. That's lousy, man, this whole, all my credibility down the drain. Police reports should be on there. And I don't know if you guys know Mr. Kaplan, but he's amazing. He can teach you this stuff as well. So that's the civil protective order side. Any questions on telling the story, civil protective orders, evidence that you can provide? Okay. Here's what I do, right? When I'm looking at these and as from a criminal defense perspective or from a respondent perspective, first thing I'm looking for is inconsistencies. Man, I love it when people tell two different stories. You wouldn't believe how much fun that is on cross-examination. That is the pinnacle of my professional career, is watching people tell a story on the stand that I know that they've told a different way, or that I know didn't happen that way, and just waiting to throw out that evidence, right? Isn't this what happened? Didn't you say this happened? And I told you we come full circle in the CJC interviews. This is why we want limited number of interviews. Okay, because if I can get 4 or 5 stories, I can guarantee you there's gonna be distinctions in the way the story is told that I can monopolize as a defense attorney. Okay, I'm looking for those. I read them over and over and over again. They live in my head, which is kind of sad because there's terrible stories that live there. But I will know if they change the way an incident occurred in court as compared to how they've written it down. Because I will read it and it just sticks in my head. I know how it happened. I've seen the video in my head. Right? So if they're changing the video, I'll immediately know that something's changed. Inconsistencies. The way that you avoid that, look at their affidavits, right? The sworn statements that they provided in any court. Look at the police reports. Make it consistent with the police reports. Okay, if there's an inconsistency, because it's possible, right? It's possible that you remember something differently, right? We've all done that. Explain that, right? Make sure you're telling the court, hey, this is why this is different. Especially if you can do that proactively, knowing that there's something that was stated incorrectly in a police report, or that, the term misremembered is a terrible term to use in court. You don't ever want to be on the stand and say, well, I misremembered that. Oh, I like that, right? Or I don't remember. Well, guess what? If somebody doesn't remember and somebody does, guess who has more credibility? Person who's telling what they remember, right? And especially because the other person isn't saying that didn't happen. They're saying, I don't remember. Like, well, if they don't remember, they don't remember. That's fine. My client does. This is what happened, right? Gotta go with the person who remembers as opposed to the person who doesn't. So watch for inconsistencies, especially with any of the other things that we talked about, any of the exhibits, right? They're saying, well, he hit me on the left arm, and then there's a medical report for a right arm sprain. I mean, that's gonna be a problem, an inconsistency, and if the attorney's doing their job and looking for those, they're gonna find it. So make it consistent, okay? Help them recall the details. If there's an inconsistency, explain it. Let's see. Oh, yeah, I mean, this is what I would say. So I can't, as a criminal defense attorney, I generally don't communicate with victims, right? Because then that looks like witness tampering. wow, it's an easy, witness tampering is a whole lot easier case to prove than assault. So I generally will keep away. Sometimes we hire private agency to speak with them just to find out some additional information. Guess what? Your victim doesn't have to talk to them. Okay, so if my PI calls and says, hey, I just want to ask you a few questions about what happened that night, you can prepare your victim for that and say, hey, you don't have to talk to anybody about this. Okay, if you want to talk to somebody about it, talk to your therapist, right? But certainly don't talk to some PI that your ex-husband's hiring just to get a better, clearer view of the case. I mean, they use the same techniques the cops do. I just want to understand. I kind of know the outcome. I just want to understand what happened in between. They're trying to get a different story. That's their job. Okay, you can tell your victim not to talk to my PI. It won't hurt my feelings. Maybe a little, but guess what? Then I'll just have to deal with it. I'm tough. I can handle it. Okay, so if if the victim isn't willing to cooperate with the prosecution, and I can find that out, I'll use that. Right? I'm gonna talk to the prosecutor and say, hey, from what I understand, your victim no longer wants this. And I can use that to either get a lesser charge, I can get a plea deal out of it. In rare cases, I can get it dismissed. But there are prosecutors who say, you know what, I don't care. I've got enough other evidence, I can go forward. So it just depends on the case, right? That's why the evidence is important. That's what I'm looking at from a criminal defense point is, what are the inconsistencies? What is the victim willing to do or say? What does the victim want as the outcome? I'm also looking at collateral consequences. Right now, the nursing board, I don't know if you all know this, but if I have a client who's charged with any kind of domestic violence charge, they will, in some instances, immediately lose their ability to work at hospitals. And that's a big deal, right? I don't know, you guys probably never had this. This probably never happens, where you've had someone who's in a victim circumstance their entire marriage. And then they feel empowered on one day and they slug the abuser. And what does the abuser do? He calls the cops, right? He's got, or she's got, whatever it is, right? Got the marks on the face that day. And it's like all of a sudden everything's flip-flopped. And wow, that's a hard story to rewrite, right? But we can do it, right? If you've got all the right stuff in place, you've got years of evidence versus 5 minutes of evidence. The years of evidence can be helpful. So work with your victims on that. But there are collateral consequences of protective orders and criminal charges, right? We've kind of talked about these. It's that loss of income, that loss of access to income, right? They'll close off the bank accounts, they'll shut off the credit cards. Your clients need to be prepared for that. That time when that individual is in jail, maybe a prime time, get some money out of the account. Maybe a prime time to set up some of their own finances. Justin, close your ears. Before the domestic relations injunction goes into effect, there's no order of the court saying they can't take all the money in the account. Right? There's probably some ethical rule about not taking all the money, but half the money is traditional. Okay, at least make sure your client has enough to get from where they are to when they can get a motion for temporary orders hearing, which can be a long time, y'all. When I first started doing this, it was 5 days between when you filed the petition for divorce and when you can get before a judge. And then it went to 14 days. I was like, oh my goodness. What's my client gonna do for 2 weeks? And then it went to 28 days. And I was like, a month without any income, what is my client gonna do? What do you expect my client to do? Well, now it can be 90, right? I just set one earlier today, 90 days out. My client's like, what do I do? I said, well, you can go and talk to your religious leader, you're gonna talk to your friends, you're gonna talk to your neighbors, you can go get a credit card. You give them some resources, right? There's food pantries. I mean, it's hard because these are folks that have probably never had to do that before. And all of a sudden in kind of a poverty type situation where they've got to mind their pennies and you've got to help them with that. So be familiar with those resources. But those are collateral consequences of criminal charges and protective orders. And then avoiding new charges, right? That's when we talk about conflicting orders, right? If in the domestic court, this happens all the time, y'all. Domestic court, you go, oh, everything's hunky-dory. I can go get my kids today. Goes over there, call the cops. He's violating the criminal protective order. Well, we just went to the judge, right? Like, yeah, so make sure that your orders are cooperating as much as you can. That's what, part of the attorney's job when my client says, hey, am I good to go pick up my kids? I can't just say, oh yeah, we went to court today, we're good, right? It's gonna be, okay, hold on, let me check all of the protective orders. Because if you don't, you're gonna miss one. So you look up their name in the exchange system and you're checking all those protective orders. Okay, so you gotta avoid new charges and you wanna avoid witness tampering, right? The children and the spouse are all witnesses. There might be other witnesses too. You're gonna have fun times with the kids. The kids will go, Daddy, why'd you get arrested? Mommy, why'd you get arrested? Well, because daddy did this or mommy did this. Yeah, that's witness tampering, right? Because you're telling them a story, especially if they were there. And they get, if they haven't had their CJC interview, guess what? That's gonna be a tainted interview now because now they have more than what was there. So avoid new charges. These are my goals when I'm talking to my client. I gotta look for those inconsistencies to exploit those. Do we have a willing victim? If not, is there something we need to talk to the prosecution about? I'm looking at the collateral consequences for my client long-term, especially with licenses. Yeah, and caregiver, making sure that they can get in and see their kids, and then above all, avoiding any new charges, because then you get a new protective order. Right? We don't want to do that. Then it makes it harder to get rid of the other one. Man, good times, y'all. This isn't complex at all. Anyway, at the end of the day, when I think about what we do, when we're communicating with our new friends that have been in these incidents of domestic violence, and we help them kind of get a little bit of their life and their control back, right? When we can give them just a piece of peace, right? We're kind of those touchstones in their lives, giving them back what they should have had in the first place, right? What we hopefully in our own lives experience on a regular basis. You all familiar with the play Our Town? Our main character, Emily, dies. And the stage manager, she meets the stage manager, who's another character, and he says, hey, we're not quite ready for you, so you can go back and visit one day that you had in your life. And all the people there saying, don't do it, Emily, don't go. And she says, I'm gonna go. She says, I want to go back to the day of my 16th birthday. So the stage changes and everything fades out, and her childhood kitchen shows up, and her mom's cooking at the stove. And Emily's there, Mama, it's me, Emily. I died, but I'm here. And her mom says, Emily, go get your brother. It's time for him to get ready. He's got to eat breakfast. Mama, I married George down the street, but then, brother Johnny dies next year, and I died, and you died. Emily, go get your brother. He's got to come down and eat. He's got to get to school. And Emily turns to the stage manager and says, don't they get it? Don't they understand? And he says, saints and poets do a few, but the rest, no. You get the opportunity for your clients to again regain that ability to be saints and poets, to realize the wonders of life. And you get to do that yourselves. So go out and do that as you're helping your clients. Help them be saints and poets and be that yourselves. Thank you. That's, let's see, how did I do on time?
Great.
All right, about an hour?
Yep.
Any other questions? I'm happy to answer any questions. Any online questions?
Not even come through yet.
All right. Well, thank you all. If you have any other questions, my contact information is on there. Feel free to shoot me an email, give me a call, and have a wonderful rest of your day. We're done early.
Thank you.
Thank you so much, Brent. Ironically, my 14-year-old and 12-year-old are gonna be in the Our Town play at their junior high, so, well, they just had that one. But thank you so much, Brent, we really appreciate it. I just think it's so important to understand kind of there's so many complexities and understanding that, defense attorney is looking at what they have to do or looking at that on the civil end. So it was great that we could hear from prosecutors today and defense and kind of get that whole picture, so. We just appreciate everyone being here. Please scan and fill out the survey. We are not offended by feedback. If we actually want to, we want to make sure we're getting the topics on that survey. You can suggest another topic you'd like. And the handouts and everything is on that other QR code that you're welcome to do. And thank you everyone for being here today. And we have wrapped up our September swaddle. Our next one will be December 4th in Sandy at the Sandy City Hall. So.
And we're
Thanks, everyone.
bringing a national speaker.
Yes, we're trying to bring in a national speaker for one in December, so, yep.
But also, please feel free, I took off the rubber bands for the bookmarks, so it's a little bit easier for you to just grab a couple different designs, take these back to your office, and if there's any other material, please let me know, we'll get that to you as well. Thank you.
Thanks, everybody.
Yeah.